Next item for deliberative order, item 34, bail application 1474 of 2024.
Petition dismissed.
Please be below. First, I would like to mention one MSC appeal for withdrawal lordship
For
for listing.
or
For withdrawal lordship.
when?
Two more lordship.
Okay.
Matt, Mr. Lordship.
Yes.
If I'd like to mention in regard to item number 20, Lordship, in that matter, the petitioner has filed an additional affidavit 2 days back, Lordship. So let them, Lordship, let the affidavit come on record, Lordship.
Today.
Yes, Lordship.
Okay.
I love that, Lordship.
Just leave you.
May it pleases your lordship. Lordship, I'm praying for an appeal.
Pardon?
I'm praying for listening of one second appeal, lordship.
When?
For admission on Monday, lordship, there is some urgency because the decree holder is contemplating to execute the decree, lordship.
When?
On Monday, lordship.
No. When the
No, they
decree
have
holder
filed-
is contemplating.
They filed the execution in the learned court below.
When?
I'm not aware of that, lordship.
Kabe, possible?
30.
Huh.
Okay, 1-2 cases.
Okay.
30.
30.
Highly obligated. May I please your lordship? I beg to mention item number 19, lordship. The agent for a day, lordship. The senior
Your good name?
D. Datta, lordship.
D. Dotto. You were appearing for?
1990.
Yeah, lordship, Mr. S.B. Laskar.
Ms. Sonso, Learned Counsel, appearing on behalf of Mr. S.B. Laskar, Learned Counsel for the appellant. Press for listing the matter after
Vacation.
vacation. Here, Lord.
Lordship, this matter, I.A. civil will be listed for order on 27/9/2024, Friday.
Yes.
Lordship,
It has to be listed on that day.
yes.
Okay.
May I please, your lordship? Lordship, with due consent of the other side, your lordship, I beg to mention item number 12 of the daily list, your lordship.
Item number?
12. We will file a reply to their affidavit of opposition, your lordship.
Your good name?
And Mohanta.
Ms. N. Mohanto, Learned Counsel. For the petitioner with consent from the other side, press for listing the matter. When? After vacation?
After vacation,
After-
immediately, your lordship.
After vacation. You? You are for?
Listen, J. Pine.
For respondent.
Any objection? No.
A date will be fixed, your lordship, after vacation.
Kabe.
28 October.
Deeply obliged, your lordship.
Item for withdrawal. Item number 35.
Lordship, the petitioner intends to withdraw his revision petition in view of his withdrawal of title suit PS 1/2023 before the learned trial court, Civil Judge, Junior Division, Nalbari.
Mr. B.K. Bhagavate, Learned Counsel for the petitioner, submits that he has the instruction to withdraw this petition. Here is accordingly allowed. This CRP instance dispose of on withdrawal. Liberty will not require.
No, Lordship.
One I is also.
I have to say order of this. Okay.
For motion, item number 1.
May I please, your lordship? My lord, we have filed this petition praying for transfer of Lordship, may kindly see PS 41, the Meiji case number 4/2024 pending before the learned district judge Kokrajar, Lordship.
What is the ground for transfer?
Lordship, the petitioner number 1 is the wife of the respondent, Lordship. She filed a case against the respondent due to killing his son. And the
Due to?
killing his son, Lordship. Page 10, Lordship, FIR. And this FIR was registered under section 302/201 IBC, Lordship. The petitioner was, respondent was arrested. Subsequently, charge sheet was submitted, and now the case is pending in the evidence stage, Lordship. In the meantime, the respondent is continuously threatening the petitioners that he will take revenge for sending him in jail, Lordship.
No, this is a petition for transfer of
Yes,
Miss
Lordship.
guardianship case number 04 of 2024.
Yes, Lordship. The son who is seeking guardianship is seeking, Lordship. He is also son of the petitioner number one, Lordship. Petitioner number one and the respondent. And the petition is filed in the court of district of Kokazar, and petitioners hail from Bongaigaon, Lordship. As there is life threatening by the respondent, she is praying for transfer of the petition. Lordship may kindly see the ground, the FIR itself is the ground, Lordship. FIR at page 10, Lordship.
Okay, heard, Mr.
M.I. Hussain, Lordship.
M.I. Hussain, learned counsel for the petitioner. This petition under section 24 stroke 151 of the Code of Civil Procedure is preferred by the petitioner. Srimati Elima Khatun and Mohammad Abdul Hussain
Yes,
and Muhammad Khanisha Bibi
yes.
for transferring of Miss within bracket Z case number 04 of 2024 under section 7 of the Guardian and Wards Act 1890 filed by the respondents
Response sole
before the
respondent.
court of learned district judge Kokrazar in the to the court of learned district judge Bongaigaon. Mr. Hussain, learned counsel for the petitioner, submits that the sole respondent is the husband of the petitioner number one, and the respondent had killed his son, for who is one FIR was lodged with the Vidyapur police outpost, upon which Bongaigaon PS case number 47 of 2023 under section 302-201 IPC has been registered, and thereafter investigation was carried out and search sheet was submitted.
Yes, Lordship.
Even
Yes.
page number,
Page number, Lordship, 15. And relevant
and
portion, Lordship.
after completion of investigation, search sheet was submitted against the respondent under section
Yes, relevant page 18, 302-201, Lordship.
302 stroke 201 of the IPC. Mr. Hussain further submits that thereafter the respondent had instituted the present proceeding. Instituted one Miss guardianship case number 04 of 2024 under section 7 of the Guardian and Wards Act, seeking custody of his another son
Yes, Lordship.
who is presently residing with the petitioner.
Yes, Lordship.
Petitioner. Mr. Hussain further submits that since institution of the criminal proceeding, the respondent has been continuously threatening the present petitioner, and as such, it is not possible on our part to attend the court at Kokrazar. Therefore, Mr. Hussain contended that Miss guardianship case number 04 of 2024 under section 7 of the Guardian and Wards Act 1890 has to be transferred to the Court of Learned District Judge Bongaigaon, where the petitioners are presently residing with her parents. The submission of Mr. Hussain needs further consideration. At this stage, notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. appeal returnable debt, further proceeding of Miss G case number 04 of 2024, pending before the Court of Learned District Judge Kokorazar stands to state. Place the
File
matter
of
after 4 weeks.
Item number 2,
May I please, your lordship? This is an application, lordship, under section 24 of CPC for transfer of the matrimonial suit filed by the respondent from Tejpur, additional district judge FTC Tejpur to district judge Hojai, lordship. The ground is, lordship, this will cause extreme financial hardship, lordship, because she is not earning. And two matters, and nobody is there to escort her to Tejpur. She cannot travel alone, lordship. And one maintenance case and another domestic violence case has already has been filed in Hojai. Those are pending, and the respondent is appearing in those cases in Hojai.
Art Mr.
B. Acharya.
Learned Counsel for the petitioner. This application under section 24 of the Code of Civil Procedure is prepared by the petitioner for transfer of TS within bracket matrimonial case number 130 of 2023 pending before the Court of Learned Additional District Judge FTC Sonitpur to the Court of Learned District Judge Hojai, Sankaradam Nagar. Mr. Asarji, Learned Counsel for the petitioner, submits that the petitioner hails from Dobaka under the district of Hojai, and she got married with the respondent who is a resident of Sonitpur. Sonitpur. After their marriage, marital discord surfaced between them, and thereafter the respondent has instituted one proceeding, being TS case number 130 of 2023 before the Court of Learned Additional District Judge FTC Sonitpur, seeking divorce from the petitioner. Mr. Asarji further submits that the petitioner has no source of income and she alone cannot travel to Sonitpur to attend the proceeding pending before the Court of Learned District Judge, Additional District Judge FTC Sonitpur, and that two other cases between the same parties are pending in the court at Hojai, and as such, this proceeding being TS matrimonial case number 130 of 2023 may be transferred from the Court of Learned.
number 3,
Malu, it's a issue under article section 115, my lord. Again, it is actually a reversal of judgment, my lord. Because we filed a title suit for eviction of the tenant. It was decreed on the two counts, my lord, that on the count of defaulter and the bona fide requirement, my lord. Now, first appellate court has, my lord, they reversed this finding, my lord. Against that, we are before your lordship, I able to under 115, my lord. Your lordship will kindly turn into page, my lord. Here is that the sole defendant was a tenant under us, my lord. He defaulted, my lord, in payment of rent. So the eviction suit was filed on the ground of defaulting the payment of rent, and secondly, my lord, on the ground of defaulting the payment of rent, and secondly, my lord, that the house is required for bona fide requirement because we are periodic construction in some part of the house, which was occurred by the tenant after he vacated the house. We started connection, but he is not vacating the house. Therefore, we are unable to
my lord, the house for the construction, my lord. So on these two counts, both the trial courts, my lord, decreed the suit. Now, my lord, the suit was that, my lord, that under section 5(4) of the Assam Urban Areas Enclosure Act, my lord, we find that is a mandate which has been given under section 5(4), my lord, that the tenant cannot suo moto, my lord, go and deposit a rent on the, my lord, the court. First, he have to offer the rent, he on the basis of, if it is on the basis refused by the landlord, only then, my lord, he can go and file a, my lord, and deposit case. Here, my
So
lord.
why the first appellate court has reversed the judgment?
Yes, my lord, first appellate court.
What is the ground?
My lord, they say he is simply based on a power of attorney. Power of attorney given by the plaintiff number 1 on the plaintiff number 2, that he should collect the rent, he should do all the works on behalf of the plaintiff number 1. So he shifted the entire burden on the, my lord, on the plaintiff. Because the defaulter is a burden which is to be discharged by the tenant, not by the landlord. Only by depending on exhibit 4, my lord, the power of attorney, he shifted the first appellate court shifted the burden on the landlord, that you did not collect the land, you did not contact the tenant, so he is not a defaulter, my lord. Secondly, my lord, the rent has to be deposited within a fortnight. I've taken a ground. If your lordship look into the exhibit, he.
Okay, at this instance, let notice go.
Yes, my lord. Yes.
Heard Mr. Ghosh, learned counsel for the petitioner. In this petition under section 115 of the Code of Civil Procedure, the petitioner has put to challenge the correctness or otherwise of the judgment and order dated 19/6. The judgment dated 29/6/2024 and the decree dated 11/7/2024 passed by the learned civil judge senior division Sibsagar in title appeal number 13 of 2023. It is to be noted here that by the impugned judgment and decree dated so and so, the learned civil judge senior division Sibsagar has reversed the judgment dated 14/7/2023. Reversed the judgment dated 14/7/2023 and the decree dated 19/7/2023 passed by the learned Munsif number 1 Sibsagar in title suit number 26 of 2016. Peruse the petition and the documents placed on record and also peruse the judgments dated so and so of learned civil judge senior division Sibsagar in title appeal number 13 of 2023 and also the judgment and decree dated so and so passed by the learned Munsif number 1 Sibsagar in title suit number 26 of 2016. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Registry shall call for the record from the learned trial court and also from the first appellate court. And till returnable date further till returnable date, the impugned judgment 29/6/2024 and the decree dated 11/7/2024 passed by the learned civil judge senior division in title appeal number 13 of 2024. Whether they have started execution proceeding?
No, my lord. Not yet started, but I am associate.
So then interim pair will be
My lord,
considered next
let
day.
me continue. If my lord, let them appear, my lord, and then lordship may modify it also, my lord. But at this day, let it be, my lord. If it's started, that is my responsible submission.
No, if no execution proceeding is started before the executing court, then let them appear. We will consider your prayer.
Let them appear. What I said, that will continue. Let them appear, my lord. Then lordship.
Okay, state till returnable date.
Okay.
Number 4.
It is.
This is against land order passed in, judgment passed in land grabbing case.
Mm.
And I am also in occupation of the land, the judgment has been passed against me. My lord, actually, the appeal, there is provision for appeal, but since no court is constituted, my lord, I have filed the civil division petition as per the judgment of your lordship.
Mm.
My lord, what happened in this case, my lord, his case is that he purchased land in 1998. In 2010, the Kacha houses. Then he inducted somebody in 2012 as permissive occupier. And this permissive occupier vacated in 2018. And all of a sudden, he found that their lock and key was broken, and I am in possession of the land. Then he filed this land grabbing case. Well, my case is that when I am the permissive occupier, when he engaged me for looking after the property at a remuneration. He did not pay the remuneration, my lord. Therefore, that, my lord, the a public meeting was held. My lord, this I have given evidence of 3 witnesses who were present and in whose house the meeting was held. My lord, proceeding was exhibited as exhibit A5. My lord, the learned trial court held on the came to misconception that, my lord, this no document regarding permissive occupation has been produced. On that ground, my lord, he has held, the learned court bill has held that I am a land grabber. My lord, page 67, my lord.
Mm. Okay, yes, Mr. Hendik, you are for respondent number,
Two lordship.
respondent number 2.
Look, that they have to make party the deputy commissioner, my lord, and other revenue, my lord, circular officer.
Not the state of
Formal
Assam.
part- Formal party, my lord.
We are, my lord, we have nothing to do, my lord, with this, my lord, that matters, lordship.
Mm.
Because the, my lord, that original custody or the, my lord, and my lord, records is be with the, my lord, deputy commissioner.
Deputy commissioner.
lordship.
Proceeding was held by the learned district judge, my lord.
Even then, my lord,
Maybe.
that this is a land dispute case.
Special tribunal.
Mm.
No land dispute, no land dispute, my lord. He is the owner. I also admit that. He is the owner. He is the owner. I'm not owner. I'm a permissive occupier. On that ground, my lord, no dispute.
Mm.
No dispute.
Let
my
the
lord. I have-
notice be issued, lordship, for the
Mm.
party.
Heard, Mr. Your good name, please.
Ekede.
AK Dale, learned counsel for the petitioner, and Mr. Hendik, learned counsel for the respondent number
Not
2.
two, lordship.
In this petition, under Article 227 of the Constitution of India, the petitioner, 2 petitioners, namely Sri Bijoy Raj and Srimati Pushpa Raj, has put to challenge the correctness or otherwise of the judgment and order dated 26/7/2024 passed by the learned presiding officer, Special Tribunal Land Grabbing, Tinsukia in LG case number 5 of 2023. It is to be noted here that by impugn order dated so and so, impugn judgment and decree dated so and so, the learned special tribunal land grabbing come additional district judge, district and session judge FTC number 2 Tinsukia has held that the respondents are land grabber under the provision of Assam Land Grabbing, within bracket Prohibition Act 2010, in respect of the suit property. And the applicant has every right, lawful possession over the suit property. Peruse the petition and the documents placed on record, and also peruse the impugn judgment and decree dated so and so so and so. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by raise their post with AD and also by usual process upon respondent number 1. Since Mr. Hendrik appears on behalf of respondent number 2, no formal notice is required to be issued. However, extra requisite copy of the petition be furnished to him during the course of the day. Rest shall call for the record from the learned tribunal. List the matter after 4 weeks. Is there any interim period here?
My lord, my lord.
Let the notice be issued.
No, otherwise, my lord, I will be evicted. But your lordship kindly see the order. The learned just this page 70.
Hmm.
The respondents.
Okay, till returnable that. Stay.
Item number 5.
Hmm.
Here your lordship would be pleased to say that actually the should proceed at expertise
Hmm.
against the respondent, against the defendant. Now, after 1 year, my lord, after about 1 year, they filed.
Mr. Sheikh,
My lord,
this synopsis you have submitted here,
my lord.
it is of only one line.
I'm sorry, my lord.
Hmm?
I'm sorry. My lord, I'm reviewing the case, my lord. I filed a title suit. After title suit has been filed, my lord, they appeared on 8/10/2021. Taken time for filing written statement. And ultimately, my lord, after 362 days, they filed the petition for vacating the ex parte order. Passed on 26/11/2021. Now, my lord, my humble submission before your lordship, they can file. They can file, but
Hmm.
where is the question of limitation is there? Your lordship would be pleased to take the CPC Order 9, Rule 7, they have filed the petitions.
So where is the impugn order?
My lord.
Page number?
My lord, I am reviewing. Impugn order your lordship will get at page 72 onwards.
So, Mr. Sheikh, the power of the learned court is discretionary
My lord,
and it has exercised its discretion.
my lord. No, my lord,
Hmm?
your lordship will
Oh, on-
your lordship will decide. Just I want to read the provision
Hmm.
under which this application has been filed, my lord.
Hmm.
Order 9, Rule 7.
Hmm. Yes.
Procedure where defendant appears on the day of adjournment hearing and assign good cause for previous non-appearance. Where the court has adjourned the hearing of the suit ex parte. Similar that adjourned case for ex parte that was on 6/11/2021,
Hmm.
your lordship. And there the defendant at or before such hearing. Defendant at ex parte hearing or before that such hearing. So, my lord, your lordship will consider that ex parte vacation petition at or before such hearing appears as the court directs as to cause otherwise be heard and answer this suit as if he had appeared on the date fixed for the appearance. So, my lord, my pointed question is before your lordship.
and the defendant at or before such hearing.
Hmm.
It means, my lord, either before the next date fixed, or before next date fixed, or on next day.
Hmm.
They have to appear and file the application.
Hmm.
Now, my lord, if after 1 year an application has been filed without supported by a condonation petition,
And what is this? The proceeding was pending when the defendant appeared and filed a written statement.
for 810, my lord, at the stage of filing written statement, thereafter hearing was fixed, we filed the evidences, my lord.
Hmm.
Defense, plaintiff PWs, my lord.
Hmm.
And now, my lord, my humble submission before your lordship consider this limitation act.
Hmm.
In the limitation act, my lord, under article 123,
Hmm.
for vacating ex parte, my lord,
Hmm.
vacating ex parte, 30 days is the limitation. 123 limitation act, my lord.
Hmm.
30 days is the time of limitation.
You are referring to article?
Referring to article 123, my lord. To set aside it, your lordship got it.
Hmm.
To set aside a decree passed ex parte, or to
No,
rehear an
no, whether,
decree or hard ex parte.
no, whether on that day ex parte decree was passed.
Well, decree, ex parte decree is not passed,
Hmm.
but your lordship would be pleased to see.
Hmm.
To set aside decree passed ex parte, or to hear an appeal decree. Last, my lord, hard ex parte.
Hmm.
That last word, my lord, my humble submission before your lordship is relevant in my case.
Hmm.
Hard ex parte. Case is fixed for ex parte hearing
Hmm.
by order dated 16/11/2021.
Hmm.
So, my lord, 30 days is the limitation. If your lordship consider that at least that the application has been filed, it should be filed properly. Limitation petition is to be there. And otherwise, my lord, after more than 1 year, a petition has been filed,
Hmm.
and that has been allowed by the trial court without considering limitation.
So where is the petition?
My lord. Petition, my lord, I am ready. Your lordship will turn to page 62. Sixty-two onwards, my lord. A petition under order 9 rule 7.
Hmm.
So, my lord, para 3, that are filed the above noted suit by the plaintiff, the honorable court issued notice to the defendant to appear before the honorable court on 8/10/2021 to file written statement in connection with the above noted suit. The defendant got summons, and after getting summons, the main defendant appeared before the honorable court on 8/10/2021 through Bokalarno, and seeking another date for filing WS. Well, my humble submission before your lordship, the file petition on 8/10/2021. And they did not,
When the order was passed?
6/11,
6?
6/11.
Where is that order?
Order of ex parte hearing, my lord.
Yes.
6/11.
Where is that order?
Yes, my lord. I'm ready. 6/11 order, my lord. 6/11 order, my lord. Page 42. Hmm. 6/11, my lord. At the top, my lord. Page 42. side is represented. Defendant side is absent. Fixing 29/11/2021 for hearing. And thereafter, your lordship would be pleased to see on 6/11/6/1/2022, plain sight is duly represented. Advocate for plaintiff White have submitted evidence on affidavit PW 1, 2, 3 with exhibited document.
So on that day, written statement was filed along with the petition?
My lord, that is on 22, my lord.
Yes,
This date of petition,
yes.
on that
WS was filed.
my lord. W was filed on the same date, my lord, when petition was filed. By 22, 12/2022, my lord. More than 1 year, my lord. 22/12/2022. Page 62, my lord, 62.
So you have filed objection to that petition,
Yes, my lord, I have.
where you have taken the plea of this delay.
The written objection, page 66, my lord.
And that's all right.
My lord,
In which paragraph you have taken that plea?
my lord, let me try to place before your lordship. My lord, para 3 may be seen, my lord. Page 66. That the order of ex parte hearing on 26/11/2021, this present petition after expiry of 1 year is not tenable in the eye of law, and hence the petition is liable to be rejected.
No, regarding this condonation of delay.
My lord, condonation of delay, my lord, that is specifically not mentioned that Article 123,
Hmm.
30 days, that is not complied with. My lord, in that case, my lord, my humble submission will be with your lordship. In the objection that may not be taken. It is a question of law, my lord.
Hmm.
It is a question of law. It can be without taking plea
Hmm.
in the written objection, my lord. I can place before your lordship the law.
Hmm.
That is the law, my lord. That if the question of law is there, supposing in my petition,
Hmm.
that particular law is not cited,
Hmm.
but that can be cited in the appeal, that can be cited in the revision, my lord. That is my humble submission. And it is strictly said that it is 1 year. So, my lord, my humble submission before you, that is one aspect of the matter regarding limitation. Another aspect your lordship would consider.
Hmm.
Under order 8, that written statement is to be submitted within 90 days, maximum period. And my lord, after amendment of 2016, it is extended to 120 days.
Hmm.
120 days means 4 months. Beyond that, my lord, there is no provision to give option to file written statement. So they file this written statement after 1 year, sitting over the matter. So my lord, that has been allowed by the trial court. Another submission before your lordship, that written statement in a civil case, my lord, they have taken the plea. We have said that this medical is false, etc. Anyhow, they have taken the plea that we are ill, we were ill. But thing is this, my lord, my learned friend, advocate engaged already. In a civil case, he can file petition that my client is ill. Nothing is here. Nothing is there. There should be, because advocate engaged, my lord, under order 3, rule 4 CPC, my lord. Advocate engaged means till finalization of the proceeding. It is his duty in a civil case to appear before the court that my client is ill. Nothing has been filed. No petition has been filed. Petition is going on without representation. And ultimately, my lord, in 2002, after 1 year, they come and say that our written statement may be accepted. How it can be? Because it was the duty of the advocate also, because advocate representing, they are not doing anything. Meaning thereby, my lord, they did not come before the honorable court in a clean hand. They want to delay the matter. And subject matter of the suit is this, my lord. I have paid the entire amount. There was an agreement for sale. I have paid the entire amount. Everything is okay. And thereafter, they twisted their position that we are not selling the land. Our money has been taken. A specific performance of contract, my lord. They refused to.
Have
do
you
this.
filed any suit
Yes, ma'am. I
for
filed.
a specific performance?
Yes,
contract?
that is the subject matter. Specific performance of suit. In that specific performance of suit, my lord, they are not filing written statement.
Hmm.
My money has been consumed.
Hmm.
This is the position, and they want to delay the matter. And delay, my lord, there must be some reason. They violated the provision under order 8, maximum period 120 days. That is also for commercial purpose. Actually, 90 days for the general purpose. I said, taking that maximum period of 120 days, my lord. Maximum period 120 days, though it is for commercial, taken that it is for general also. Then also after more than 1 year, how they will file written statement. And what advocate was doing, nowadays, my lord, communication is very improved. Everybody has a telephone that we are ill, so you take steps. That instruction is not with the advocate. Advocate is not doing his duties. Well, how it can be allowed? That is to be looked
But
into by the
Mr. Sekar, have you filed your Wakalatnama in this case?
only. Which case, my lord?
In this case?
My lord, in this case, my lord,
Hmm.
again, I am to point out before your lordship.
So without Wakalatnama,
My
how
lord,
can you
in
appear?
that case also, my lord, I will refer to another law.
Hmm.
That order 3,
Hmm.
rule 4,
Hmm.
provides that my learned friend is the advocate on record. He
Hmm.
requested me to argue.
Hmm. But without filing any Wakalatnama?
No, my lord, without filing any wakalatnama, my lord, as my
But
learned friend.
you were also
My
not
lord,
the
may I
designated
please
senior
please
advocate.
Order 3. Order 3, Rule 4, my lord. Order 3, Rule 4. TPC, my lord. So your lordship, subsection 4, Rule 4, subsection, sub-rule 2. Every such appointment shall be filed in court and shall for the purposes of sub-rule 1 be deemed to be in force until determined by the leave of the court by writing signed by the client or pleader, as the case may be, and filed in
And,
the court until.
well, you have not taken leave of the court.
My lord,
You file Ukalanama, we'll fix another date. We'll
Hello.
consider your prayer.
my lord.
Heard Mr. M.S. Singh, learned counsel for the petitioner, leaves the matter on Friday for further consideration. In time you file Ukalanama, we'll hear you.
My lord.
Item number 6.
Your lordship, but this matter has some interested lordship, so I may be allowed to withdraw this application. Because the MSC case has been disposed of.
Acha. Mr. Coletta, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. There is accordingly allowed the service since dispose of on withdrawal.
Lordship with some liberty to file appropriate application if necessary.
However, liberty will remain with Mr. Coletta to approach this court again by filing appropriate petition.
Item 7.
Lordship, there he issued against the limitation lordship. Because the accident, MGA case member, because the accident took place for the amendment of the MGA, and it was filed beyond the period of 6 months as provided by the section 166 of the MGA lordship 2019. Here lordship, the accident took place on 2011-2022, and the claim application was filed before the MSCT Nagaon lordship. 13/7.
What is that impugn order?
Lordship.
Page number?
Page number lordship 34. Impugn order lordship. Page number 34 is the that the application was filed, and impugn order lordship is page number 42 lordship. Page number 42, which I am challenging. There is this case arising out of the application filed under section 5 of the Limitation Act lordship, because there was a delay of 53 days. That delay was condoned after hearing both the parties, and we raised the issue of section 166 subsection 3 lordship, because the section doesn't provide for any extension of time lordship.
When the accident took place?
Accident took place on lordship 20 November 2022, 2011-2022. And the application was filed on 13/7/2023. So there was a delay of 53 days.
Application was filed on
13/7/2023. 13 July. And also after filing the application, they also filed the respondent claimant lordship. They also filed one application under section 5 of the Limitation Act, and that was allowed by this impugn order lordship. And we have raised the issue. We filed written objection as well, pointing out this provision of section 166 subsection 3 lordship. That is why we have approached lordship.
Whether any case has been registered in respect of the said accident?
Yes, lordship.
What is the number?
It is lordship Nagaon PS case number 136022. This is reflected in page number 22. This is the claim application, Lordship.
Page
We do-
number?
Page number 22. I'm reading from the claim application. Page number 22, Lordship, may kindly see. In this case, Lordship. Para 8, Lordship, date of accident is there. Para 9, the reference of police case, Lordship.
Page number?
Page number 22. There is a box, Lordship.
Hmm.
8, clause 8, Lordship, date of
Hmm.
accident is there. And clause 9,
When this case was registered?
Lordship, initially it was not registered. But the claim application was filed on 13/7/23, and by the impugn order dated 21/3/24, which I am challenging, Lordship, the claim application as well as the delay application was allowed. Lordship, may kindly see
No,
again.
no, Mr. Kolita, I'm asking you, when this police case was registered?
Lordship, I have not, don't have the FIR copy, Lordship, because the date of registration is not there, Lordship.
Hmm.
I only expect.
So it was
finding
immediately after the accident?
the case was registered. Lordship.
Hmm. You produce the copy of FIR? We'll see, because there is one judgment of Madras High Court that
Lordship.
this FIR may also be
Yes, Lordship. that is-
treated as a
yes,
claim
Lordship,
petition.
that is why Lordship, I may be allowed to place, Lordship,
Hmm.
because there is a judgment of the Honorable Apex Court, Lordship.
Hmm.
The judgment I have brought, Lordship, from Gohar Mohammed.
And the
Lordship.
accident information report
Yes.
can also be treated
Yes.
as a claim
Claim
petition.
application.
Hmm.
Lordship, as per the Gohar Mohammed judgment,
Hmm.
there are 3 ways that one claimant can claim for compensation, Lordship.
Hmm.
One is by approaching the Honorable MSCT by filing an application under section 166.
Hmm.
And there is another section of 164, Lordship, is there.
Hmm.
And the third one is the police report based case, Lordship.
Hmm.
Except 166, in 164 and police report based case, there is no provision of limitation, Lordship.
Hmm.
Because this claim application would be registered as and when the police report is forwarded to the learning member MSCT, Lordship.
Hmm.
Now, Lordship, may kindly see, I am placing, Lordship,
Hmm.
that judgment.
Hmm.
That Gohar Mohammed judgment, Lordship.
Hmm.
I'm reading paragraph 40, Lordship.
Hmm.
This has been delivered in respect of new MB Act, Lordship.
Hmm.
On perusal of the scheme of the Act, it is clear that as a first recourse, by not pleading or establishing proof of wrongful act, neglect or default of the owner or driver or of the vehicle, the compensation can be claimed under section 164, but such compensation is of limited amount to the tune as specified in the case of death or grievous injury. The second recourse available to the claimants is to apply by providing wrongful act and neglect to the owners or drivers before the claims tribunal by opting the jurisdiction at a place specified under subsection 2, but such claim application must be filed within 6 months from the date of accident and be adjudicated by the tribunal. The third recourse has been prescribed by introducing section 149 of the MB Amendment Act, by which in case the claimants have failed to take recourse under section 164 or section 166 within the prescribed period of limitation, the report submitted by the investigating officer to the claims tribunal within whose jurisdiction the accident occurred may be treated as claim application under section 166(4) and would not debar the claimants to seek compensation if he or they could not file the application under section 166(1) of the Act. Lordship, that is my point, Lordship. If he approaches under section 166, Lordship, 1, that has to be filed within 6 months of the occurrence of the accident. Otherwise, not, Lordship. Because he had the other two options. That options are open, Lordship, for the claimant, for claiming compensation, Lordship. Lordship, I may be allowed to place one more judgment, Lordship. Because there's a judgment of Honorable High Court of Telangana. So here in this case, Lordship, this issue had been raised on limitation, Lordship. There also, my lord. Because in that case, Lordship, the case, the WPC had arisen out of rejection of a claim application by the landed member MSCT. Then the claimants had approached the Honorable High Court of Telangana, Lordship. And Lordship may kindly see the last page, Lordship, the finding. Last page of the judgment, Lordship.
Yes.
Having regard to the paragraph number, Lordship, having regard to the composition of the claims tribunal and the finality of each award, a prima facie view can be taken that it has all the trappings of a court, and therefore section 5 of the Elimination Act would be attracted. That being the position, as an interim order, we direct the Motor Accident Claims Tribunal Nizamabad to take on board the two claim petitions filed by the petitioners and proceed with the same on merit. Insofar as the larger issue raised in this petition is concerned, the same would be addressed once the counter affidavit is filed by the Union of India. That issue is, Lordship, is regarding the applicability of section 5 of the Limitation Act in section 166, Lordship. And Lordship, this judgment, Lordship, Telangana High Court was challenged before the Honorable Apex Court, and Honorable Apex Court had stayed the judgment, Lordship, that I have placed the order. And it is pending before the Honorable Apex Court, Lordship, that issue of application of section 5 of the Limitation Act, Lordship.
Now you produced before the court the FIR lodged in this case. And also the information whether accident information report was forwarded to the claim tribunal or not. We'll fix a short date.
No, Lordship.
Heard Mr. Polita, learned counsel for the petitioner. The petitioner, Bajaj Alliance National, Bajaj Alliance General Insurance Company Limited has put to challenge the correctness or otherwise of the order dated 21/3/2024, passed by the learned member MSCT Nagaon. It is to be noted here that by the impugn order dated 21/3/2024, the learned member MSCT has condoned the delay of filing the claim petition before it. Mr. Kolita, learned counsel for the petitioner, submits that in the new act, there is no provision for condonation of delay. New MB Act, there is no provision for condonation of delay in filing claim petition. And as such, the impugn order dated 21/3/2024 suffers from illegality and impropriety, and therefore Mr. Kolita contended to set aside the same. Having heard the submission of Mr. Kolita, it is provided that Mr. Kolita shall produce before the court the copy of FIR lodged before the Nagaon Police Station, based on which Nagaon PS case number
136022.
1360 of 2022 under section 279, 338, 337 IPC. And also to apprise this court as to whether any accident information report was forwarded to the learned member Motor Accident Claim Tribunal Nagaon or not. List the matter immediately after reopening of the vacation.
Okay, can I pray before listing, before vacation, Lordship, because the proceeding is going on, Lordship.
Okay. 1st of October.
Much of it.
Item number 8.
May it please your lordship.
Mm,
The lordship, on the last occasion when the matter was taken up,
mm,
your lordship had directed us to produce some copies of the medical documents which we had relied in a petition that was filed by the respondents.
mm,
Lordship, that has been filed with the additional affidavit for medical documents on 21st of September. That is flag mark as A for your lordship. Now, what has happened? May I just recollect your lordship's para 14 of the at page 14 of the main revision petition.
mm,
Petitioner submits that the onus upon the respondents is of a higher degree to plead satisfactorily demonstrate a valid reason for not filing the written statement within time.
mm,
A careful perusal of the medical documents enclosed to the petition 900 dated so and so, Annexure 12 reveals that test reports of respondent number 1 are within the normal range which was referred to by a dentist. Admittedly, therefore, no extreme hardships or factors beyond control of the party have restrained the respondents from filing the written statement within the time, despite proactive diligence. Now, your lordship will kindly come to the relevant pages of the affidavit that was filed on 21st. Lordship will first come to page 56. Now, it has been referred by Dr. Ravinder Singh. He is a dental surgeon from Tinsukia. Then the next page, same doctor at page 57 also. 58 also the same condition. 59 is also the same. Then 60 is also the same one. Then regarding pages at 61 and 62, it has been referred by the respondent herself. So if your lordship will kindly come to the main revision petition, your lordship will first come to page 36. Page 36 is the type copy of the order for the first time when the respondents appeared before the special tribunal. Page 36. Petitioners are represented. Respondents file petition 437, praise for time for filing written statement. Now that prayer was allowed. Fixing 4/5/2024 for written statement. On 4/5 also, they again file a petition 658, praise for time. That was also allowed. Now your lordship will kindly come to page 35 for a moment, your lordship. What is the content of the grounds taken for seeking an adjournment? Page 35. That today is the date fixed for filing written statement. The respondents have engaged their lawyer on the last week, and due to paucity of time, the conducting lawyer could not able to study the file properly, and as such, the written statement could not be prepared and filed. Now your lordship will kindly come to page 38. They again file a petition. Despite best efforts, the opposite parties could not able to collect all the relevant documents for preparing the written objection of the case. As such, the written objection could not be prepared and filed today. So again, on 5th of June, the same plea was taken. So that way they kept on taking time. Finally, the court on 5th of June, that is at page 43, passed the order. Seen petition number so and so filed by the opposite parties praying for fixing another date for filing written statement. There was another petition by us. On the last occasion, your lordship has put a pertinent question to us whether we had raised objection or not as to why the petition, as to why the written statement was not filed in them. That your lordship will find at page 39, the petition that was filed by us. Page 39. The humble petition of the applicants above named, that today is the day fixed your Honour's tribunal today, an application was filed. Now, what had happened on an earlier occasion, your lordship, when we filed a land grabbing case, the special tribunal was not inclined to grant a stay order. So we moved the Honourable High Court in a High Court, and High Court, after hearing the parties, that is at page 33. In FAO number 55 of 2023, after appearance of both the parties, had passed an order. The relevant portion is at page 34. This is an application filed under Order 39 Rule 1 CPC challenging the order dated so and so passed by the Executive District so and so. The petitioner has filed an application under Order 9 Rule 13, 39 Rule 1 and 3, read with Section 151 CPC, praying for injunction. The trial court refused to grant ex parte injunction and issued notice to the parties. Being aggrieved by the aforesaid order, the present appeal has been filed. Now, what the court directs, after hearing both the sides, this court is of the opinion that the trial court should hear both sides before passing any order. Therefore, the matter is remanded to the trial court. The present respondent shall be at a liberty, shall be given an opportunity to file an objection on the next date, and accordingly it will appeal. And that was again fixed. So, lordship, though they appeared for the first time on 18-3, it was within their knowledge that they have got notice. Officially, we are taking the date of their appearance on 18-3. From 18-3 also, if your lordship takes into account, their period of 90 days elapses by 16th of June. Though they earlier appeared before the trial court and before the High Court, it was within their knowledge. So that is why at page 39, when we filed this petition before the Honorable Trial Court, Special Judge, Special Tribunal, the court, we had raised that objection. But subsequently, on 5th of June, the court also recorded our petition that was filed at page 43. Seen another petition dated 8/33 filed by the petitioner's side, stating that they know the opposite parties appeared on 18-3 without filing any written statement and failed to file the same within 14 days from the date of appearance and the mandatory limitation period of 90 days. It has already elapsed. The petitioner further submitted that this court extended the time filing for fixing today, and as such, the respondents may be debarred from filing the written statement. So we raised the objection, your lordship. But thereafter, finally, court grants fix 19/6/2024 filing written statement with a cost of rupees 3,000. Thereafter, that was on fixing 19/6. Thereafter, they filed. Thereafter, they appeared on 19/6. Again, they sought time. At page 45, your lordship. The order of Annexure 12. Page 45. Annexure 12. Seen the petition bearing 900 filed by the respondents praying for another date for filing written statement. Heard the learned counsel for both sides at length on this petition. The learned counsel for the applicants has vehemently raised objection against this petition. Considering the facts of the case, petition is allowed. However, it is ordered that this is the last and extreme chance given to the respondents for filing written statement, failing which the case shall proceed as per law. Fix 26th of June for filing written statement by the respondents with cost of rupees 3,000 as ordered on 5th of June. That was the previous order. Now what happens on the next day, that is on 26, they again file a petition. That in pursuance of the order of the Honorable Court, the respondents have filed a written statement against the petition of the applicants. As the respondent number one, so and so, being an ailing lady, and as such, respondent number two, Samsher Singh, is busy with his ailing mother. The respondents, who is 85 years of age, suffering from various ailments, unable to move, etc. As such, they could not able to collect and provide the relevant documents and information for preparing the written statement, and as such, they could not able to file the written statement on the last dates, for which your honor was pleased to allow the respondents to file the written statement with cost of rupees so and so. That the respondents state that the reason for non-filing the written statement on earlier days was not at all intentional, but due to the circumstances beyond their control. Now, your lordship may take into account what was the situation beyond control. Because as I have already pointed out to your lordship, on the earlier occasions, the grounds were very flimsy. They could not collect documents. The lawyer could not prepare it. The previous petitions were on those grounds.
So on 26/6/2024, they have filed a written statement.
Yes, they filed a written statement, and interestingly, the court had waived the cost of rupees 3,000 that was earlier imposed. The same court without any reason, without hearing us, had waived the cost and allowed it. And your lordship, there are Katina.
No, in the order, first line, very first line, both the parties are represented by their engaged counsel.
Yes,
Now, how can you submit that you have not been heard?
no, we had only filed our Hazira.
Hmm.
Now, your lordship will say the respondents have jointly filed the written statement along with the document. The respondent number two has filed a petition stating that the respondent number is aged lady and so and so, so and so. And as such, accepting the written statement filed on the petition, also prays for waiving the cost
Hmm.
of rupees 3,000 imposed by the order dated 5/6. So they should have heard us, or we should have enabled us to give it further time so that we can hear it before the written statement was accepted. And they should have given us the time, because we are the aggrieved persons within the definition of the Section 8 of the Land Grabbing Act. And so far as the provisions of Section 10 is concerned, the provisions of CPC and the CRPC are applicable to the proceeding before the Land Grabbing Act also, in the Land Grabbing Act. And there are catena of decisions in the lordship by the High Court, where it has Supreme Court, wherein it has been stated that as regards the timeline for filing written statement, however, it would be gainsaid that although the unamended section of is directed, it cannot be interpreted to bestow a free hand to any litigant or lawyer to file written statement at their own sweet will or to prolong the list. The legislative objective
Now you tell me after how many days the written statement was filed?
that was filed on 26.
After
After it will be, your lordship, 100 days.
after 100 days.
100 days. Or on the 100th day. They first appeared on 18th of June. From the materials available on record, it appears they appeared on 18th of June. So in the month of, they appeared on 18th of June. Sorry, 18th of March. So in the month of March, they get 13 days. In the month of April, they get 30 days. In May, they get 31 days. In June, they get 16 days. So positively, they should have filed it by 93rd day on June 19th. They again delayed it by another 7-8 days. Because the provisions of CPC also, your
So,
lordship.
Mr. Sudhur, it is not that they have not assigned any reason. They have assigned a reason also. This
No, reasons they
medical
have assigned.
documents are.
I am not on the reasons. Now, what is important is that if your lordship will peruse Order 8, Rule 1, it is provided where the defendant fails to file the written statement within the said period of 30 days, he shall be allowed to file the same on such other day as may be specified by the court for reasons to be recorded in writing, but which shall not be later than 90 days from the date of service. Now here, if your lordship peruses the petitions that were earlier filed,
They did not give any genuine reasons which were beyond their control.
Hmm.
Your lordship will kindly come to page 38. Page 35 is the first petition of the revision petition. The respondents have engaged their lawyer last week.
No,
And
you see, the learned court has exercised its discretion. So the provision is also not mandatory but directory.
No, then you have to, lordship will have to see how the Honorable Supreme Court has interpreted. Honorable Supreme Court has said the legislative objective behind prescription of timelines under CPC
is,
must be
who is-
given due weightage.
In which judgment that observation was made?
Your lordship, I'm just submitting the copy, 2020 2 SCC, page 708.
No, before that, in the case of Salem Advocate Bar Association case, Supreme
That
Court
has
has
been-
clarified.
That has also been covered in this judgment.
Hmm.
And in Salem Bar also, it has been said that in exceptional cases, it should be considered.
Hmm.
Your lordship will kindly come to paragraph 15.
We'll pass the order, we'll see.
In this regard, your lordship may kindly take into consideration ground number 5.
Hmm.
That may be just noted. Ground number 5, ground number 3, 4 as well. Because the provisions of Land Grabbing Act says that section 10 says that provisions of CPC and the CRPC also to be taken into consideration. As per section 10, may I just read the section 10, your lordship? Procedure to be followed by special tribunal. Save as other-
Not necessary,
No,
no.
I'm just refreshing your lordship.
Not
That's
necessary.
okay, so lordship.
Ground number 5.
Ground number 5, 3, 4. There I have taken the specifically as to how the provisions of
That is
ordering
ground number 4, 3, 4, 5 of your petition.
of your of my petition, your lordship.
Okay. Okay, we'll pass the order.
Lordship may also take into note ground number 11.
What is ground number 11?
That is also regarding the dental surgeons reference to the documents they have submitted.
No, you have submitted along with your affidavit another document that
No.
is issued by one Ramesh Agarwala,
No,
physician,
that
cardiologist.
was
and
annexed with the entire annexure 11 that was part of the main revision petition. Annexure, I relied on petition number 900.
Mm,
Now, petition 900 that was filed before the special tribunal
mm,
has enclosed these documents.
mm.
So inadvertently, I did not file it before your lordship. So the leave was taken, leave was granted by your lordship,
Mm.
allowing me to file those documents. That Agarwala's document is also part of their annexure.
No, yes,
Yes.
but it shows that she has been suffering from hypertension and some other.
But how did it prevent them from filing the written statement?
No, the contention is that the person was busy with the treatment of this lady, old lady.
Now, without hearing the other side, we are the agreed persons under the Act of 2010.
Okay, we'll see.
And the cost that was imposed earlier, they did not agitate the imposition of the cost.
Hmm.
They waited till the time that court liberally granted that time. When the court accepted the written statement, they filed a petition that even the cost should be also waived.
Okay, we'll see.
Obliged, Your Lordship.
Items for admission, item number 9 and 10.
Lordship, hearing this matter, Lordship, though the pleadings are complete, Lordship, I have misplaced the file, Lordship. So, Lordship, I need a week's time to reconstruct, Lordship. Let it come immediately after vacation, Lordship.
No, my lord, it is unnecessary lingering.
Lordship, we have filed our
That submission is not a reliable submission, my lord. Each and every time 3 years they taken for filing their objection, my lord.
We have filed, Lordship.
And subsequently filed after imposing cost.
Not.
And
no
today
court.
file is missing. Parties are going to be retired.
In fact, also this case can be disposed of because this is a covered case.
It is
Pardon?
covered case.
It's a covered case, not say, my learned friend has bought one judgment, he has shown you. Covered case. They have made an objection with regard to, let's say, time frame. If this he has given a verificatory notification,
Produce the covered case, or which is the covered case?
Yes, sir.
Lordship, in that case, can this matter be taken up on Monday, Lordship? Monday, Lordship.
Monday,
Monday is motion day, my lord.
Monday is motion day.
Before vacation,
Lordship may
Lordship.
kindly peruse that order, Lordship, the division may order. Nothing.
I will need, Lordship, 2-3 days time, Lordship. That's it.
No, if it is covered case, why time is required?
I will have to go through the brief,
Hmm?
Lordship.
Second file is there.
Second file you can take.
My lord, the second file maybe
Covered case, this is of Punjab and Haryana High Court.
yes, my lord. Same issue on the same issue.
Lordship, I'll have to go through it, Lordship. On Friday, Lordship, then.
Friday.
Yes, Lordship.
Immediately after vacation. Very first. 21st.
So when the person is going to be retired?
My lord, it is series case three matter is my lord one after 2 years and first case is Mitali Sharma is some days
After?
after she has another 4 years now.
Another 4 years.
My lord.
So we will take it up immediately after reopening.
Yes, Lordship. A date may be fixed, Lordship.
As
Yeah,
because, my lord, so
Let him go through the file. Let him go through the file. Heard Mr. Your good name?
KU Ahmed.
A.E. Ahmed, Learned Counsel for the petitioner, and Mr.
D. Upamanyan.
D. Upamanya, Learned Counsel for the respondent number,
Lordship, Standing Council, Higher Education Department.
Standing Counsel for Higher Education, and you,
SK does for the college,
S.
principal.
S.K. Das for the respondent number.
He is respondent, my lord, 4.
4.
Yes.
Respondent number 4, and you,
On behalf of Mr. A. Somapuri.
okay. Mr. Upamanya, Learned Counsel for the
Higher Education.
Standing Counsel for the Higher Education submits that he has lost his file and press for granting him some time so as to enable him to reconstruct a file. Peer is accordingly allowed. SSL is the matter on
21st of.
21st October.
My lord.
So, Mr. Counsel, you furnish one copy to him.
Yes, Lord.
Please.
My lord, so on that I will furnish.
Item 11.
May I please the lordship, my lord.
Hmm.
My lord, matter pertains to my lord provincialization of service of the petitioner, my lord.
Hmm.
What happened in this case, my lord? A list was prepared by the district scrutiny committee in Nagaon, my lord.
Hmm.
My lord will kindly find at page 30, my lord. Kindly have a look. my lord. Page 30, my lord. This is the list forwarded by the district scrutiny committee, my lord. If not the concerned authority. my lord. Along with the, my lord, my name along with other teaching staff, my lord, appeared. My lord will kindly have a look in the next page.
Page number 13.
30 minutes, 30 election.
30, okay.
30. The school is my lord, LP school, my lord. Who I'm looking as a major LP school. So we are having diasport, my lord, that's from the year 2009.
Page number 30.
30 minutes.
Where your name appears?
My name appeared in the next page, my lord. 31 months. I am the headmistress of the school, my lord. Serial number 1, my lord, in the left side.
Nehar.
Lindatul Nehar, and serial number 2, my lord. The name of another, my lord, assistant teacher of the school, my lord. His name also appeared. Surprisingly, my lord, the post of this particular person, my lord, serial number 2, Abdul Aziz. His service was provincialized and my name was dropped, my lord.
Why?
Without assigning any reason.
By
My service was never
no,
provincialized.
who dropped your name?
Yeah, higher authorities, my lord. The list was forwarded before the concerned director and the state level scrutiny committee, my lord. And without assigning any reason, my lord, although the service of the other, my lord, assistant teacher was provincialized, but my name was dropped, my lord, and my service was not provincialized, my lord. But as per the, my lord, teacher and students ratio, my lord, kindly have a look at page 30 again, my lord, or should kindly have a look. In the right hand side bottom, there are 2-3 boxes, my lord. 2014, 15, 16, and 17, my lord. As per 17, my lord, last year, 72 number of students, and right from the year 2014, there were 117. In the year 2015, 108, and in the year 2016, 104 students were there, my lord. Accordingly, my lord, as per ratio, my lord, that is the ratio is, my lord, 30:1, my lord. Meaning there were, my lord, 30 students will be covered by 1 teacher, my lord.
Where it is stated? 30:1.
That is in the act itself. That is
Here, in this document, what is the ratio?
if we calculate the ratio, my lord, right from the year 2014, it seems that there should be, my lord, more than 3 persons, my lord, name required to be provincialized. But the district scrutiny committee, they had forwarded the name of 2 teachers, including me and another, my lord, assistant teacher of the school. But they did not provincialize my service.
So 3 persons required as per?
But the students, number of students shown in 2014, and if we go by that current year, when it was sent, the 2017, the number of students seems to be 72 in total. And accordingly, my lord, at least, my lord, 2 teachers services should have been provincialized, including me. As such, my lord, the district committee, my lord, they had forwarded the list, including my name along with my teacher, my lord. This matter is, my lord, pending, my lord, since long that, my lord. It was filed in the year 2022, my lord. They did not file the reply till date, my lord. This is a admitted position of the case is that on the basis of, my lord, the material available on record, my lord, my prayer may kindly be considered, my lord, to issue a direction to the, my lord, authorities, my lord, the respondent authorities to consider my prayer, my lord, for provincialization of service. Since because the assistant teacher, my lord, his service has been provincialized, he is working in the same school, my lord.
Yes.
Lordship, can you take up that annual Lordship, page number 123. He has an alternative administrative remedy available as yet, Lordship.
Page number?
Page number 123. This is section 14 of the 2017 Act, Appellate Authority. So if he has any grievance against the state level authority, he has to prefer an appeal. Section 14. The state level scrutiny committee shall be the appellate authority. Has the Lordship got it, Lordship?
Yes, got it.
The state level scrutiny committee shall be the appellate authority against any recommendation of the district scrutiny committee, and the state government in the concerned administrative department shall be the appellate authority against any recommendation.
You first tell me who dropped her name.
Lordship, there is no denying that the district level committee has recommended his name to, because LP school teachers, there are 2 teachers, services of 2 teachers are provincialized. Now, in so far as the petitioner is concerned, I have a report that that DICE data against his name is not available.
Pardon?
That district information system of education, DICE data, which is maintained by the Sarva Shiksha Abhiyan mission, which is one of the important criteria to get the service provincialized. But in respect of the petitioner, that Daesh data in against his name was not there.
Milord, it is
Yeah,
there, it's a
he's-
part of record, page 27, Lordship will kindly have a look.
I have received
Let him complete.
I have received the instruction, Lordship.
Hmm.
I'm submitting on the basis of the instruction.
Hmm.
The SSA furnished the Daesh data in respect of the all proposals received from the concerned DEOs for provincialization of services as per Provincialization of Services Act 2017.
Hmm.
State level scrutiny committee scrutinized all the proposals and found that as per the records furnished by the SSA Assam, the name of the petitioner, Jinatul Nehar of Pub Amleki AS Ahmadiyya LP School does not appear in Daesh data maintained by NEOPA New Delhi up to 2012 and 13. Hence, state level scrutiny committee as well as joint committee recommended only the service of Abdul Aziz, the only petitioner, the other one, for provincialization against Purb Amloki AS Ahmadiyya LP School. So his name was not recommended by the school level committee because his name was not available in the Daesh data, which is one of the important criteria to get the service provincialized. So now he has an alternative remedy available as per section 14. Let him prefer an appeal before the appropriate authority. They will verify.
No, merely because a alternative remedy is available, we cannot say that this writ petition is not maintainable.
Yes, Milord.
But otherwise also, then in that case, we will need to file affidavit in details first. I will file an affidavit.
Here, may I
Giving
clarify
the
one thing? If your Lordship permit me, Milord,
Hmm.
I may be allowed to clarify, Milord.
Pardon?
Milord, regarding the diaspora, Milord.
Yes,
Milord will
you are
kindly-
referring to page number 27.
27.
Then Daesh data is maintained by the SSA. So let SSA also.
Milord, Lordship will kindly have a look, page 27.
Yes.
This is the DIAS code, which is mandatory, which is required to be maintained right from the year 2009, Milord.
Hmm.
My name appeared with serial number 1 in the left side, Milord.
Hmm.
Jinnatul Nahar.
Hmm.
And my learned friend is submitting that my name did not appear in the DIAS code, Milord.
No, there are
This is a part of record, Milord.
There
This
are
were
two systems
furnished.
of, may I submit, Lordship? There are two systems of maintaining Daesh data.
Hmm.
One is in respect of the school and the other one is in respect of the person concerned.
This is regarding person.
Whether the name of the school appears in the Daesh data of 2009 or before, they are entitled for provincialization, schools. And insofar as the teachers are concerned, whether the name of the incumbent appear in the Daesh data 2011 and afterwards, not before, and afterwards, whether they are continuing in the job or not, 2011 and afterwards, in respect of the teachers, and in respect of the schools, 2009 and prior. So in respect of the Daesh data of the
No,
petitioner.
this appears in the year 2009.
2009, 10. And thereafter
2009,
I have
10.
also annexed the another copy, my lord. Page 29, my lord. Lordship will kindly allow me 2 minutes time to submit. My lord.
Yes.
Lordship will kindly have a look at page 29, annexure 8, my lord. This is also, my lord, the DIAS data pertaining to the year 2019 and 20, my lord.
But in respect.
My name also appeared, my lord. Lordship will kindly see the second box, my lord, right hand side, second column.
Hmm.
My name appeared along with this assistant teacher, my lord, and other teachers. Accordingly, my lord, if my name would not have been appeared or reflected in the DIAS code pertaining to the year 2009
Hmm.
and thereafter, my name would have been, my lord, forwarded or recommended by the district level scrutiny committee for provincialization.
Hmm.
This is very clear, my lord. And regarding this article, my lord, section 14, my lord, this case was preferred in the year 2022, my lord.
Hmm.
Thereafter, my lord, this case was admitted by this honorable court, my lord.
Hmm.
And accordingly,
The
on many
maintenance
occasions,
paper also.
they have sought time, and now they're submitting without filing their affidavit. They're submitting that I have a alternative remedy. I should go to the appellate authority and file a, my lord, appeal before the concerned authority.
Hmm.
That is not sustainable, my lord, at this stage.
Hmm.
But the question of maintainability all along we have raised, Lordship.
No.
Lordship, may kindly peruse the last
Since the
order.
case is admitted,
So
my
far
lord,
as the maintainability is
now
concerned,
sufficient time were granted to them, my lord.
Hmm.
To submit, they got sufficient time to submit their written reply, my lord. Got the instruction
Hmm.
to proceed in the case. They never, my lord, cooperated in the.
No, what is your submission regarding this page number 27?
Yes.
Because it pertains to academic year 2009 and 10.
Lordship.
So her name is appeared at serial number 1.
Lordship, there are two system of appearing the name in the Daesh data.
Hmm.
One is for the school Lordship.
This is in respect of what?
In respect of the petitioner,
No, no,
Now,
this,
all
there's a page number 27.
But a code is given to school, my lord.
Hmm.
Now he is trying to categorize in two different categories. I do not understand, my lord, because since the code is given to the, my lord, school, my lord, concerned
Hmm.
school, and accordingly, the name of teaching and non-teaching stuff, they are, my lord, covered with the help of this code number, my lord. This code is
So
also. there.
who is for Sarva Shiksha? From? It appears that her name is there in this page number 27. That's serial number 1.
Lordship, it does appear, but Lordship, it's only part of the DIAS course certificate, Lordship.
Hmm.
Part of the record. Where is the other part, Lordship? Because Lordship will see that at the top it is part C
Hmm.
teachers.
Hmm.
Lordship, the other, if he can produce the other part of that document
Other part relates to what?
of the school, Lordship, it will be clear because it's not of one page, Lordship.
Hmm.
Because the first page reflects about the dice code,
Hmm.
what is the number given. Thereafter, the school details from number of students to teachers.
So a school
like-
code is there.
School code is there, but name of the school
But
is also. there.
Lordship, whether this continue thereafter or
Hmm.
the dice code is in relation to the school only or teachers, that doesn't reflect, Lordship.
Hmm. No, it does reflect. You see, it is C related to teachers.
Yes.
Yes, my lord.
Hmm.
My lord, the left hand side, my lord, in the top, my lord, the school.
That I have seen,
code is also
Lordship,
there, my lord.
0100.
It will be available in the
Hmm.
official website. even.
Then
He can produce it, Lordship, short time
It
maybe
is
given,
in
he
their custody,
he
my
may
lord.
produce that. It's
And
not
not-
in our custody,
It may not
Lordship.
be available with the petitioner, my lord. Since they are
That's-
made to a necessary party, my lord. It is available in the official website of my lord service system.
Lordship, that certificate is given to each and every school, whoever applies for getting the dice code, Lordship.
My
Hmm.
lord, at this point of time, my lord, that may not be a crux of the case, my lord. Since because my name appeared in the DIAS code right from the year 2009, my lord.
Hmm.
As such, after scrutiny, my lord, the district scrutiny committee, they had recommended my name along with one teacher, my lord.
Hmm.
And that post was provincialized and I was dropped, my lord. This is my case.
So there are two persons from the same school.
Yes.
One is one service is regularized and the other is not.
Both fulfill the same criteria, my lord.
Hmm.
This is a very shocking part. my lord. Both fulfill the same criteria and accordingly, one post was provincialized, other was dropped, my lord. And then now they are categorizing, my lord, this, that my name was captured in respect of name and in respect of institution, two kinds of, my lord, numbers are given to us.
It cannot so happen, Lordship. Lordship, kindly take section
This is a wrong submission. my lord.
3110 of the 17 Act, Lordship. It clearly provides two number of teachers and tutors of the venture LP schools, Lordship.
Page number?
Page number 111, Lordship. 3110. When the section 3110, Lordship, it is page number 11, 111, Roman 10, Lordship.
Hmm.
When there is a provision, two numbers of teachers and obligate tutors of the venture LP schools shall be provincialized under this act, and their services shall be merged with the basic schools identified in respect of the area where the said venture schools was situated. So there are provision for two teachers to be provincialized. So there is no question of provincialization, only one teacher and leaving aside the other one, unless they fulfill the criteria, which includes the DICE data. Because insofar as my instruction says that insofar as the petitioner is concerned, his name does not appear in the DICE data, Lordship.
I have shown
Because
that,
Data gives the details of students, teachers, school, and the enrollment position of the
but
students.
I
everything
fulfill
is
every
there.
criteria, my lord. I have shown, my lord, for your
And
lordship.
so far as the teachers is concerned, their data has to, the name has to be appear in the data 2011 and afterwards, in order to show that he is in service. He is continuing in service. But in respect of the petitioner, his name doesn't appear in the data of 2011 and afterward, which instruction I have placed before the lordship now.
At page 27 and page 29, lordship will kindly consider me.
Okay, we'll dispose of the petition.
Yes, my lord.
Heard Mr.
Zaid Hamad.
Zaid Ahmad, learned counsel for the petitioner, and Mr.
P.N. Sarman.
The number,
Response number, lordship. Elementary Education Department, lordship, response number 1. One and 5, lordship.
respondent number 1 and 5, and Mr. Sorori for respondent
Lordship,
number.
one issue is there, the arraying of parties is a bit problem because the respondent number 2, it has been stated Director of Elementary Education, come the mission director. These are two separate entities. Lordship. It cannot be combined together,
No, that is corrected letter.
It was corrected.
but our.
In that case, I am for 1 and 2, lordship.
1 and 2, and Mr. Sorori, you are for respondent number?
It will be Lordship SSA, Lordship numbering maybe. Mission Director, Tower 6 Alpha.
Okay, respondent number 3.
Fine.
Respondent number 3. Argument concluded, order reserved.
Deeply honored.
Item number 13.
May I please? My lord, this is my lord, first appeal, my lord. Under section 96 of the CPC, my lord.
Under section
96 of the CPC. Against the judgment and decree dated, my lord. Filed by the civil judge, the senior division of Udalguri, my lord. Dated 12th of July 2024, page 48. In fact, my lord, two appeal filed, my lord. One, my lord, against the dismissal of the suit, and another appeal, my lord, against the allowing of counter claim. But the first is listed, my lord. The appeal against counter claim not yet listed.
heard Mr. S. Sohan, learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure is directed against the judgment and decree dated 12/7/2024 passed by the learned civil judge senior division Udalguri in TS number 02 of 2021. It is to be noted here that by the impugn order dated so and so, impugn judgment and decree dated so and so, the learned trial court has dismissed the suit filed by the appellant. Whereas the memo of appeal and the grounds mentioned therein, and also whereas the impugn judgment and decree dated so and so so and so. Let notice be so let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by result of. Rest shall call for the record from the learned trial court. List the matter after 4 weeks.
Item 14.
Yes.
My lord, the petitioner before your lordship are, my lord, basically drop teacher. Hereafter, my lord, as per the judgment at page 15, my lord. Drop teacher, my lord, means, my lord, initially their school was provincialized.
with limited, my lord, post. But due to, my lord, lack of, my lord, sanction post, my lord, their service could not have been, my lord, provincialized at that point of time. Therefore, my lord, they are called job seeker. As per, my lord, this judgment at page 15, my lord, their service was, my lord, virtually, my lord, provincialized. This judgment was passed, my lord, by the Honorable Court, my lord, on September 1, 2003, my lord. And following that, my lord, their services were provincialized, regularized, my lord, page 34. Under, my lord, their new pension policy. Yes, my lord, they were already directed before the new pension policy for regulation of their service with, my lord, past service benefit. And they approached before this honorable court once again, page 36, my lord. And this petition was disposed of on page, my lord, 38, 14/12/2015, and, my lord,
And to your lordship, also here we have to require to file affidavit lordship. Even the department as well as the finance also lordship. Because these matters, even in the earlier occasions also came up before the other coordinating banks lordship. And we yeah, in detail affidavit. The lordship may fix after vacation lordship, because the affidavit from the finance department also will be required lordship.
now, my lord, they are, my lord, as per this page 38 order, now, my lord, we are taken under, my lord, old pension policy. This is order page 42. Lastly, it is order, my lord, and the GPF account, etc., is issued by the account general. And they are, my lord, now under old pension policy, my lord. But as per, my lord, they are joining, my lord, page 42. Date of joining, my lord, right hand side, my lord, 18/1/1995, my lord. But they are not getting, my lord, incremental benefit, my lord.
No, whether that was provided in the order.
My lord, there. Without, my lord, incremental benefit, my lord, they cannot, my lord, provide us, my lord, the old pension also, my lord.
Presently petitioners are in service lordship.
Yes, we are
Yeah.
in service.
They have number of years left as yet.
Okay. Heard Mr. A.M. Barbuya, Learned Counsel for the petitioner, and Mr. Sarma, Learned
Yes,
Counsel
Sarma.
for the respondent number.
Response number lordship 1 and 3 lordship.
1 and 3, and Mr. Mehdi. Respondent number 4.
This is the finance lordship.
None appears for the rest of the respondents. Mr. Sarma submits that he may be granted 2 weeks time to file a affidavit here in this case. Here, finance department or 2.
Finance also require to file affidavit lordship.
Respondent number 2, Mr. Sarma, Learned or 3, submits that he may be granted 2 weeks time to file a counter affidavit in this petition. Where is accordingly allowed. Rest shall is the matter after immediately after reopening. Let them file affidavit.
My lord. Item number 15. Apply.
Also here we have listed our instruction lordship.
In 15.
In 15 lordship.
Mm.
Lordship will allow 2 weeks time. We will file it. We will receive the instruction.
What is the matter?
Which matter relating to my removal of precedent from the SNC matter.
Removal of
SMC, School Management Committee.
Acha,
President
acha.
of the School Management Committee, or School Management, the petitioner was selected as the president by the parents of the school, as the president of SMC. Thereafter, my lord, response number 5 was also selected as the vice president, and later on, vice president, response number 5 was made president and petitioner made vice president, reversing the position. This is the case. Let them file affidavit, my lord.
Okay. Heard, Mr. R. Islam,
Islam.
Learned Counsel for the petitioner. Mr. Sharma, Standing Counsel for the respondent number
Phone number, lordship, 1,
2.
2,
1, 2.
1, 2, 3, 4, 3 and 4. 1, 2, 3 and 4.
1, 2, 3, and 4. Submits that. Mr. Sharma, we have granted you time by order dated 6/9/2024.
Lordship, by next week, 2 weeks, lordship, we have received instruction from the last.
Submits that he has received written instruction and he will be filing affidavit, and therefore Mr. Sharma submits that he may be granted 2 weeks time to file the counter affidavit. Pair is accordingly allowed. Recessal is the matter after 2 weeks.
Item 16.
That lordship, this matter relating to non-payment of salary as well as lordship. The inquiry was conducted against the petitioner who was not implemented. The fact of the case is that lordship, petitioner was serving as a block elementary education officer lordship during his service period lordship in the month of July 2017 lordship, and FIR was lodged against him under section 8 of POCSO and 354A lordship. Since a non-available section was, the case was registered, so he took leave and came before this Honorable High Court for anticipatory lordship. Then lordship, the Honorable Court satisfying the argument as well as the case, appraisal of the case diary, lordship kindly see page 22, his bail was granted. It will also bail order.
No, that's all right, but what is your pair in this
Now,
case?
lordship, case to lordship, an inquiry was conducted, lordship, and the inquiry for the case, 30 lordship, case 30. This is a forwarding letter by the Director of Elementary Education addressing to the Secretary of the Government of Assam. Now the next page, 31 is the inquiry report lordship. The inquiry report lordship. Date of hearing, the top, 5/12/23 lordship. Now to the conclusion lordship, finding in the middle, may read lordship, findings in the middle. On perusal of the record and report of District Elementary Education Officer Sonitpur, the delinquent incumbent so-and-so was allowed CL with effect on so-and-so. Subsequently, DO Sonitpur received a letter dated so-and-so issued by the in-charge Bevejia Police House Post PS Tezpur Sonitpur, wherein in the in-charge Bevejia Police House Post has informed the DO Sonitpur to pass an order to Sri so-and-so petitioner lordship and instruct him to appear before the IO Bevejia outpost on so-and-so. As per letter of the in-charge Bevejia Police Outpost dated so-and-so, DO Sonitpur issued a letter to so-and-so Bhai so-and-so lordship dated so-and-so. Appear before the IO Bevejia Police Outpost on or before 4/8/23 in connection with PS case number so-and-so under section 354A IPC repeat section 8 of POCSO Act. The in-charge Bevejia Police Outpost has mentioned in his letter that so-and-so is absconding to avoid police arrest. Now he is on period bail from the Honorable Guwahati High Court, High Order dated 12/9/23 in so-and-so AB number. And he joined in the office of the DO Sonitpur Tezpur on 15th September 2023 lordship. I have joined 15th September 2023 from the record lordship. This course of action as per outcome of the police may initiate against delinquent incumbent under the provision of the Assam Service so-and-so lordship. Now look at conclusion lordship. This is inquiry. It came to notice that the accused incumbent Ravichandra Shil, DO Gavuri, is involved with the allegation against torturing a minor girl who was kept in his residence as a child labor, for which affair has been lost and the video clipping published in DY 366 News Channel. The Bevejia Police Outpost registered a case so-and-so. As stated, he was absconding from service with effect from, the date is important, 21/7/23 to 1/8/23, as reported by the Bevejia Police Outpost, which is punishable under so-and-so lordship. Therefore, the GOVT may be requested for one lordship, no work, no pay during that period. he may be imposed stoppage of one annual increment with incumulative effect of the incumbent. He may be transferred to the other district and also one not to repeat such type of illegal activity in future, Lordship. These three proposal was given, Lordship. They have not acted, and I am not getting salary from August 2023. And although I have joined from the report 15th of September, Lordship, the DO had not allowed me to join, alleging that since the case is registered against you, we cannot allow. I have stated my paragraph, Lordship, in my writ petition, Lordship. Now, Lordship, I am hanging. In the meantime, Lordship, during my service, now I came to know 3rd of August 2024, I have been placed under suspension after this inquiry, Lordship. Now, Lordship, the case was filed in the March 2023. For last 10 days, it was running after day after instruction. The last occasion instruction was given, but till that they have not filed affidavit. And there is a court order, Lordship will find, there's a direction to give the salary, Lordship, 3524. Kindly see, Lordship, for a moment.
Page number?
Court's order, 3524. Court's order, Lordship. Three five 24.
Yes.
Yes, Lordship, where is the last pay directed to pay the salary, Lordship? 3524. And subsequently, Lordship, 19/6/24 also, the order of the earlier was retracted by the order dated 19/6/24. Then also they have not paid the salary, Lordship. And they affidavit took time for instruction. And this honorable court last occasion, 19/6/24, Lordship, see the order. In this order also, earlier order of 3524 was retracted regarding the salary part, Lordship. 19/6/24. 19/6/24. Pursuant to the direction passed by this honorable court, by order so and so, pertaining to the release of the area salary of the petitioner, Lordship. This is the order. Thereafter, they again took time, and 15/7/24 they said they need time, and this court 15/7/24 order, they have given the last chance, Lordship. Then also they have not filed the affidavit. And this way, this court is immediately giving time. And last occasion, Lordship, 2/9/24, they said that they have got some instruction, but and fixing it today, Lordship, but till that no affidavit has been filed. And his family members somehow running, even if he's suspended, he's not able to pursue the another case, Lordship. From August 2023, he is not giving his salary, Lordship.
My lord, regarding the salary, my lord, I have received the instruction, my lord. As per my instruction, he was unauthorized absent, my lord, and the report of the DEO, my lord, on the basis of the report, my lord, the Joint Secretary of the Government of Assam passed.
I have duly applied from
Madam,
record, Lordship. I
I
have
may
duly
be allow some time so that I can bring it on record, my lord.
Lordship, maybe my leave was unauthorized by applied, Lordship, but that suggestion is that no pay, no work. That should be implemented, Lordship, the period counting for which I was unauthorized absent as per their statement. But record, from record, I will show, Lordship, I was present and my leave application was granted by the authority, Lordship. I have enclosed there also. The absent is not unauthorized, Lordship. And the inquiry has been done, Lordship, pursuant to the government order, Lordship. And the inquiry suggested they have to act on this, Lordship. Either three of you, I am ready to agree, Lordship. I have done 15th of September 23, but not allowed to me work. I have stated my declaration also, Lordship, will find.
Oh, he has joined on a 15/9/2023. So thereafter you pay the amount.
As per instruction, my lord, there is no record found that he is joined, my lord. And you see the next page, my lord, that Deputy Inspector.
Hmm.
report.
Page 31, Lordship, where the inquiry report says, I join Lordship, from the inquiry report of the department, Lordship. And one Prasanna Bora, Lordship, deputy director, he was the inquiry officer, and Pradeep Kaur, superintendent, Lordship, presenting officer. Their report, yes, on page of the record, this hit, and I have included the joining report also, Lordship. Annexer 5, page 28. My joining report. How they can say that I have not joined, Lordship? From their record, it proved that I have joined. But it is a fact, Lordship, they did not allow to me discharge my duty, Lordship. I have mentioned in my petition also. Therefore, I am before this court, Lordship. In spite of this inquiry report, they have not acted on this. Page 28, Lordship, kindly see my joining letter, Lordship. Page 28. That is 15th of September, Lordship, regarding joining of regular duty. May I read, Lordship? With due respect, it is stated that undersigned BO, BMC, Gaburu, Block Limited Officer, Tezpur, Sonitpur wants to inform you that due to illness, health, matter of myself and parents and other unavoidable circumstances, I did not attend that regular duty with effect from 17/7/23 to 14/9/23. Dates are with effect from 17/7/23 to 27/23. I have applied for CL through 2 numbers of application as per process, which was already being known to you. And with effect from 1/8/23 to 28/23, I have applied for earned leave in 2 spells, 1/8/23 to 1/8/23, 10/8/23 and 11/8/23 to 28/8/23 through handwritten application, and which was prescribed God format to your office. Also from 1/9/23, I applied for extraordinary leave for 2 months up to 30/8/23 on self and parents' health checkup and care ground. Now myself feels mentally sound and physically I want to withdraw extraordinary leaves with effect from 14/9/23 onwards and for the remaining applied days. He withdraw, Lordship. In view of present Gov. Assam duties and responsibilities of Amrit Vikas Andolan and coming Gunotsav 24, I want to join my regular duty in my block office, Gaburu, Tezpur, with effect from 15/9/23. And from the report, Lordship, it appears I have joined, Lordship, and I have included this, my joining report, Lordship. For a moment, Lordship, kindly see page 31, the joining report, Lordship, from the inquiry report.
No, where is the evidence that you have, no, the authority has received this joining report?
Lordship, the inquiry report, Lordship. The inquiry report, Lordship, this is, they have produced, Lordship.
Because this is the report of Deputy Inspector of School, Tezpur. Here it is stated that you have not joined.
No, Lordship.
Record is necessary, my lord, in this.
Hmm?
Record is necessary, my
Lordship,
lord.
I-
Whether
Which record?
Record is, why, Lordship, I have joined it, I am also showing, Lordship, on my, in the meantime, Lordship, during my absence, Lordship, I also joined for urgent work, Lordship. Kindly see for a moment, Lordship, is 26, Lordship. This is received, Lordship, by the Block Limited Officer, Lordship. Page 26, it is not visible, Lordship, so type copy is there, page 25, Lordship. Page 25. Address will be the DO, Lordship. Page 25, type copy from Block Limited Officer dated 28/7/23 to District Limited Officer, Sonitpur, joining report. With due respect, it is to state that myself, the undersigned, has joined duty 28/23 at forenoon and resumed the essential works. This is for a kind of necessary action, Lordship. Received, Lordship, 31/7/23. The page 26, Lordship, will get the receipt, Lordship. The office of the DO, they have the endorsement, Lordship. Receipt in the left of the bottom side, Lordship. So these are the documents which shows that I was in between my leave period, I also joined, Lordship. And finally, withdrawing all my leave, I
my lord,
joined.
28/7/2023. Subsequently on 15/9/22. When
That's 15, then I withdrawn and I joined, Lordship. And Lordship, this is how I'm saying, Lordship.
Lordship,
This
may
31,
immediately
this
after
is-
vacation, my lord.
No, Lordship.
In the meantime, Lordship may call for the record, my lord, and I will produce the same.
There is a order, Lordship, by this for last chance. For 9 months, they have not filed any affidavit and taking time, and I have not getting salary. There is a order of this honorable court to pay the salary, Lordship. Current salary and zero salary. Twice this court is
Regarding current
directed.
salary or salary, my lord, The instruction revealed that he is not entitled for the salary.
Re-election is not.
Whether he is unauthorized absent without.
Something, this is the court to decide, Lordship. Some instruction.
Immediately after vacation, my lord.
No, in that case, Lordship, my period debt, my current salary may be directed to pay, Lordship. Otherwise, it's difficult to survive, Lordship. They having their family, all these parents, every time they are taking time, Lordship, with different ground.
Last sum.
And my prayer, no, last month already given in on, given, Lordship, on,
Okay, heard Mr.
as you.
S.U. Ahmed, learned counsel for the petitioner, and also heard Mr.
B. Talukdar,
B. Talukdar, learned standing counsel for
elementary education, my lord.
elementary education department.
As per my
Mr.
lord.
Talukdar submits that he may be granted some time to file written statement. Oh, no, sorry. Defeat in opposition. Mr. Ahmed, learned counsel for the petitioner, submits that sufficient opportunity has already been given to the respondent authorities to file their affidavit in opposition. And last chance was also granted, but they failed to comply with the order of this court. Further, Mr. Ahmed submits that the petitioner has assumed charge of his office on, who is that?
15/9/20.
Pardon?
15 September.
On 15 September
2020.
2023, and this court by order dated
65/24 and 19/6/24, directed to two orders. 15/6/35/24 as well as 19/6/24.
A5 2024 and
19/6/24.
19/6
Yes.
2024 was placed to direct the respondent authorities to release the salary of the petitioner. But despite the specific direction of this court, the respondent authorities have not been releasing his salary. And therefore, Mr. Ahmed contended that the necessary direction may be issued to the respondent authorities to comply with the order of this court dated 3/5/2024 as well as 19/6/2024. Having heard the submission of learned advocates of both sides, it is provided that the respondent number, who will release your salary?
Respondent number 1, 2, and 4, Lordship. Since I am on leave, Lordship, they are not allowing, so all the respondents except respondent with 3 are directed to release their salary.
Respondent number 1,
1,
3,
2,
and 4.
1, 2, and 4, Lordship.
1, 2, and 4 are directed to comply with the order of this court dated 3/5/2024 and 19/6/2026 and to file compliance report before this court on next date. Mr. Talukdar, learned standing counsel for the education department, shall also produce the relevant file from the office of the block elementary education officer,
My lord.
from where you will produce the record.
From director of business, respondent number 2.
From the office of the director,
Elementary education.
elementary education, on next date. List the matter after, immediately after reopening of the vacation. When?
Okay, Lordship. If the salary is, there's no issue, Lordship. The time may be given, Lordship, before vacation, Lordship. This specific date, Lordship may be given the regarding salary part only.
Okay, within a period of within a period of 2 weeks from today,
Regarding salary, Lordship.
the petitioner shall produce, obtain a certified copy of this order and produce the same before the respondent authorities for compliance.
For bail hearing, item 17.
What is the second bail application, Lordship? Lordship, the earlier bail application was rejected on dated, Lordship. Please. 25/11/2022, Lordship. This is the last phase of my petition lordship, I have annexed the order lordship.
Hmm.
It was rejected and was by giving a direction lordship. On page number 103, below part lordship. Lordship, if you have to- For having a direction that lordship to expedite the trial in respect of the present accused, and if necessary, the learned court bureau shall take rescue of the provisions of section 3091 of the CRPC lordship. Lordship, in this case, lordship, I am totally lordship 1065 days lordship. I am behind the bar lordship. I was arrested in this case lordship on 25/10/2022 lordship.
1000.
1065 days lordship. And the bar lordship. In this case lordship, I was arrested in this case only having a statement of 67 of the co-accused lordship, and on the basis of the lordship, all details lordship. Nothing has was recovered from me lordship. In this case, seizure took place lordship on 6/10/2022 lordship. On my paragraph number lordship, I have stated paragraph number 3 lordship. I have stated that lordship was 6/10/2021 lordship. Seizure took place in this case lordship, and I was arrested in this case lordship on 25/10/2021 lordship. It is before of my arrest lordship. In this case lordship, my total submission is based on the paragraph 7 and 8, but I have stated in my petition lordship. On page number 6 lordship, paragraph number 7 lordship,
Yes.
may I read lordship? The pursuit of the complaint filed lordship on accused, the whole case is rest upon the statement record under section 67 of the NDPS Act by the present accused as well as other co-accused. It is settled principle of the law that the statement recorded under section 67 of the NDPS Act is not admissible in law.
No, Mr. Dubey, this is settled position. You
Yes,
are
yes,
not
lordship. But lordship,
required
I
to
have,
argue on this point.
yes, lordship, I have.
So what is the ground for filing this second application? You tell
lordship,
me.
the ground is the delay of the delay
Delay.
in the trial also lordship.
Delay.
Yes, lordship, delay in the trial.
When the charge was framed?
Charge frame lordship,
17/2/24 lordship,
17 to 24, 22,
24.
24.
17 to 20,
For lordship,
24.
yes, lordship.
How many witnesses cited in the final report?
8.
Total 8 lordship.
2 witnesses have been examined.
It's not formally confirmed that lordship 2 witnesses examined lordship because LCR is there lordship, and total lordship 8 witnesses have to be examined yet in the court lordship. And they have, I have a witness list also there lordship. I have a witness list lordship, and they also stated their lordship, any more witnesses submitted, then they will. Lordship. These are all the part lordship.
Wait. What was the report? So that's the report, it's a coroner. What are you doing? Scan copy of the record as well. So according to you, only one witness is examined.
Lordship, actually, I have not confirmed in that lordship, that's what the LCR was called for lordship. And it's in court number, lordship, the additional session court on 2/4/2022 lordship, the case was transferred in the additional district and session judge number 4 lordship. Till date, the case is pending there lordship.
Lordship, last witness was examined on 19/9 lordship, 24.
19?
9/24 lordship, deposition of witnesses are not there in the record lordship. I have checked the record, Lordship. Deposition of witnesses are not there.
You take a long time again, Lordship. More witnesses have to be examined this case, Lordship. There was more than 6 Lordship. And only for the 2 Lordship, you take it up to 3 years, Lordship. So the better-
That's all right, but the quantity of contraband substances allegedly recovered from the possession of the accused persons are of commercial quantity. You were to satisfy the twin condition of section 37. How do you satisfy it?
Lordship is having a problem of the insertion, Lordship. It's a long pending trial also there, Lordship. There is a violation of the Article 21 of the Constitution also there, Lordship. Though I am there, Lordship, I'm the behind the bar, Lordship, but delay of the court, this is not bothered on me, Lordship. Delaying of the court is there, Lordship. My submission is that, Lordship, the long time, Lordship, I'm behind the bar, Lordship. And this having a more than 3 years,
See,
Lordship.
this deposition of PW2 is not available. One is available.
Lordship.
We'll call for that deposition. We'll say. Heard Mr. Dobe, learned counsel for the accused, and Ms.
Decca.
Decca, learned counsel appearing on behalf of Mr. S.C. Kyle, learned standing counsel for the NCB. Ms. Decca submits that one more witness has been examined here in this case on
19/9/24.
19/9/2024, but the said deposition is not available in the record of the learned trial court. But having considered the submission of learned advocates of both the parties, it is provided that Registry shall call for the deposition of the PW2 examined on 19/9/2024, and also to call for an up-to-date status report from the learned trial court fixing the matter on short date. No. August. 3rd of October.
Obliged.
So in the meantime, Lordship, we will file our objection.
So up to you. You may file or may not file.
Highly obliged.
Obliged.
Item 18.
CD was called for. Yes, hard application, my lord.
What is the ground?
The other co-accused are granted already bail, my lord. Main accused also granted regular bail, my lord. Only allegation against us, my lord, that we have registered one.
This is a PRS bail application.
Yes, my lord.
So recently, Supreme Court has observed that granting bail in anticipatory bail in NDPS cases is unheard of.
Actually, my lord, nothing was recovered from our possession, my lord. Only allegation against us, my lord, that once Saddam Hussein police was going to arrest one Saddam Hussein, my lord, and some villagers along with us, my lord, released them police not to arrest the person, my lord. That is the only allegation. Only last.
So what is the stage of investigation?
Some persons are yet to be arrested, Lordship. Those who have.
Otherwise, material part of the investigation is over. Material part of the investigation is over. Search it submitted or not submitted? Not submitted.
But some persons are who attack the police persons and they held in plea they were the accused persons because of their attack. Those accused persons whom police has arrested, they have pleaded, Lordship. And there are some injuries are also there, Lordship. The police person also. Police persons went there to went for arresting some person, and then these persons attack them, and they held in pleaded with the accused person.
Main culprits.
Then
Male culprit was
always, Lordship, there is no any phrase gun, Lordship. Earlier this is the third application, Lordship. There is no any phrase gun for granting them. There is no any sense of circumstances, Lordship, that which.
Okay, we'll see. What is the case, Eddie?
Lordship.
Item 36.
Dispose of it, Lordship. Dispose of.
We'll pass the order.
May I please, your Lordship?
Hmm.
Did you call from?
Did you receive, Lordship?
The petitioner is an advocate by profession.
Hmm.
Like the petitioner is an advocate by profession. He is no way involved in this case.
No way.
No, yeah, mother.
How many cases are pending against him?
I'm sure.
How many cases are pending against him? No knowledge. A CD receipt?
Did you receive, Lordship? Sufficient materials are against him, Lordship, and he is the main person who made that fake receipt, Lordship.
Where is the CD?
That Alice is here. I'm giving you. Itu. That is 18, itu 18.
আগৰটো নেকি?
36 itu. It is under that, he is also an accused also, co-accused also. His statements are there also.
You have marked the
Also, I have met all everyone's statement also. Ratul Ali, he is also, his statement is also there also. So many person statements are there, and he is not on this, not only in this case also, as per the statement of the accused, co-accused person, he is engaged in, involved in other cases also also.
what are the numbers?
Also. Those numbers are not been mentioned.
Then how do you justify your submission?
It's a general irrevocable, general power of attorney was preferred by
Hmm.
him.
Hmm.
In between Godoli Deka and one Amir Hussain.
Hmm.
Godoli Deka is the recorded Patadar,
Hmm.
the said puller of land.
Hmm.
The, it is not proved that the general irrevocable general power of attorney is fact. It is not proved, my lord.
Hmm.
And
No, statement
Godoli
of
Deka,
Godole Deka is recorded by the IO. Godole Deka stated that she had never sold any land. Heard me, sir? Your good name?
P. Ahmed.
Learned counsel for the applicant. And Mr. P. S. Locker, learned additional PP for the state respondent. This application under section 482 of the BNSS is prepared by applicant Moinul Haq, who has been apprehending arrest in connection with Dispur PS case number 384 of 2022 under section 341, 347, 427, 34 IPC, added section 120B, 468, 423, 471, 409 IPC. Is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Devabroto Mohanto on 17/2/2022 with the inserts Udalbekra Police Outpost. The essence of allegation made in the FIR debut so is that his father
Narayan Mount.
he had a plot of land registered in the name of his father, late Narayan Chandra Mohanto, bearing DAG number 888, pattern number 191 of Haukusi. And some unknown person have blocked the road, blocked the government road leading to his land, and taking that sense, some unknown persons have filled up his plot of land and trying to grab the same. Mr. Ahmed, learned counsel for the applicant, submits that the applicant is a practicing advocate and he is no way involved with the offense alleged in the FIR, and that the recorded pattadar of the land, namely Srimati Godoli Deka, has executed one general power of attorney in favor of one Amir Hussain.
Lordship,
Page number this 15.
17. Okay, please 15.
Amir Hussain.
15.
And that said power of attorney is not disputed, and on the strength of which the land was sold. And the present applicant is no way involved in the same. And that he is ready to cooperate with the investigating agency, and therefore it is contented to allow this application. Whereas on the other hand, Mr. P. S. Locker, learned additional PP, has produced the case diary before this court and submits that the IO has collected sufficient incriminating materials against him, and that the offenses are serious in nature and his custodial interrogation is required, and therefore it is contented to dismiss the petition. Having heard the submission of learned advocates of both the parties, I have carefully gone to the petition and the documents placed on record, and also peruse the case diary with the assistance of Mr. Locker, learned additional PP. Case diary indicates that the IO has collected sufficient incriminating materials against the present applicant. The offenses are also serious in nature, and investigation is going on, and it cannot be said that custodial interrogation of the applicant is not required in the interest of investigation. Accordingly, this court is of the view that this is not a fit case where the privilege of peer's bail can be granted to the applicant, and accordingly the petition is dismissed, case diary be returned.
Also, let me mention item 33.
Item
33, Lordship. Mr. Chitti Sharma, Senior Counsel, he was about to appear through VC link. But the link could not be established, Lordship. Can this matter be taken up on Friday, Lordship? Some urgency.
Colby? Item number
33, Lordship. All those.
So is there any urgency in the matter?
Lordship, the execution has already been filed, Lordship. For the IA was filed for condemnation of delay, Lordship. Friday, Lordship, it won't take much time.
No, no. We have a lot of cases on Friday. It may not, your matter may not raise on that day.
Lordship may be taken up as the last item. Yes, under this.
Possible. Okay. As prayed for by Mr.
D. Deca, Lordship.
D. Deca, learned counsel for the applicant, rests the matter on Friday as last item. Yes,
Regarding substantial question, in respect of advanced question. Here, my
in respect of,
advanced question, claiming advanced question. Now, my lord, here last time I argued, my lord, page 33, my lord, that while the learned trial court, while discussing this, the question of advanced question, he issued, that is exhibit number 4. He said cancellation of exhibit number 4, which is a license, my lord. I brought in by way
affidavit.
of an additional affidavit.
Yes.
But that the cancellation of the license shows that I am not in possession. But my submission, how discussion of these issues, my lord, shows by the cancellation of the license shows me prove that I am not in possession. I am still in possession, my lord. That is the adverse position, my lord. Can you see, my lord, discussion of the court below, my lord?
No, you first show me the annexer A.
No, annexure, no, exhibit 4, my lord.
Yes.
Annexure, yes, sir. My lord, by way of an additional affidavit, I brought page 66, running page.
Yes.
That is exhibit 4, my lord. My lord, the trade license 524 for a stationery shop to them, holding number so and so, what number so and so, hereby revoked with immediate effect as licensee could not obtain NOC from actual owner of the holding. It was brought to the notice of the owner of the building by petition number 6/2013, my lord. A licensee is hereby directed to stop his business at the place as referred to above. My lord, I stop business, my lord, but there I stay, my lord. That is the house, my lord. Still in my position. As on date, they file execution case, my lord. And that is why it is a case of adverse position, my lord. Because, but first of all, since 2002, I am in position. That is why he has filed suit for eviction, my lord. Had I been not in the position, my lord, against the original owner, he would not have filed suit against me for eviction. Now he has filed execution case, my lord, for execution of this decree, my lord. That means still I am in position, my lord. The cancellation of the license, how would show that I am not in position, my lord? My position advanced since 2002 till date. Beyond the period of 12 years, my lord. Limitation. That is why only one substitute question I framed, my lord. Only one. Kindly see, my lord, my substitute question, my lord. Technically, both substitute question comes together, can be clumped together. The page 3, my lord. Appeal raises a substantial question of law as to whether the finding of the learned court below suffers from perversity in view of the exhaustion of the evidence in respect of adverse question claimed by the appellant defendant. Appeal raises a substantial question of law as to whether the learned court will act in violation of the law laid down under section 64 of the limitation. And here, once my lord, after 12 years, my lord, he filed the suit for eviction. My lord. Now, ultimately, the rest, my lord, this is a crux issue, issue number 2 and 3. My lord, learned court has come to the conclusion mainly on the basis of this, my lord. The cancellation of the license, that means I am not in possession, my possession has been disrupted, my lord. But that is not the case. My case is I am still holding the possession. That is why he has filed execution case, my lord. I've also filed an IA, my lord, for the stay of the execution.
So, why this, 64, section 64 limitation act?
Yes, immediately. Yes, for possession of immovable property based on previous possession, not on title, when the plaintiff while in possession of the property has been dispossessed, 12 years, date of disposition. Yes, filed this suit in 2016, my lord. I claim, my lord, I have been in possession since 2002. I mean, brother, my, it is not the interest property, this is the purchase property, my lord, of the respondent, my lord. He's my brother, my lord, advance question will lie, my lord, because it is purchase property. That is there in the plain itself, my lord. He said he didn't pay. Only one issue, my lord, that let your lordship decide, my lord.
Okay, heard Mr. Sudhuri, learned counsel for the appellant. This second appeal, under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 31/10/2023 passed by the learned additional district judge Hailakandi in title appeal number 01 of 2022. Is to be noted here that by the impugned judgment and order dated so and so, the learned additional district judge Hailakandi has dismissed the appeal and thereby upheld the judgment and decree dated 3/12/2018 passed by the learned civil judge Hailakandi in title suit number 28 of 2016. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the relevant documents, and also the impugned judgment and decree dated so and so passed by the learned additional district judge Hailakandi and also by the learned civil judge Hailakandi. This appeal is admitted on the following substantial question of law. Whether the learned trial court as well as the first appellate court correctly decided the issue of adverse position in view of the existence of evidence. The second question is not relevant, I think.
Yes, only one will do, but both are interconnected actually. One question will do, but.
Let notice be issued to the respondents are returnable in 4 weeks. Step be taken by registered post with ADM. Today, Regis will call for the records from the learned first appellate court and also from the court of learned trial court. List the matter after 4 weeks. Is there any IA?
Yes, my lord, order 41, rule 5, my lord. In the prayer, my lord, I mentioned, my lord, in the plaint or petition also. Execution case number 10/2024 is pending for the trial court.
our orders. Okay, we state the operation of the.
Yes. 21.
All right, ma'am.
Thank you a lot. My lord, this is the regular setting appeal, my lord. Against the order, my lord, the fact of the case is one title suit number 11 of 2018 was instituted by the, my lord, respondent as a plaintiff, my lord. There we were the, my lord, the defendant. My lord, thereafter the suit was decreed in favor of the my lord, the opposite party here, my lord. And our, my lord, counterclaim also dismissed. Thereafter, we filed a title appeal, my lord. And in this, preferring the title appeal, my lord, there was a delay, my lord. And while we submit the application for delay condemnation, my lord, that was rejected, and consequently, my lord, title appeal also dismissed, my lord. So, my lord, I have some substantial question of law. In page 9, my lord, I have stated, my lord. And lordship may kindly see the order by which, my lord, condemnation petition was rejected, my lord. That order will find lordship. Page 86, my lord. So as per, my lord, the finding of the learned, my lord, the first appellate court, that I have not stated the sufficient ground, my lord. And that will be
Mr. Uddin,
lordship.
this substantial question of law
Yes.
are not part of this memo of appeal.
Yes, my lord. Lordship may kindly see page 9 of my.
9 is a separate sheet,
Yes, substantial question of law. Okay.
but it appears that subsection 3 to section 100 has not been complied with.
100.
See, subsection 3 to section 100.
Lord, it is with the memo of the appeal only.
Hmm?
With the, I have submitted.
This is a low sheet. It is enclosed after the prayer.
Yes, my lord. And thereafter ground also, my lord, I have made, my lord.
You comply with subsection 3. Only then we will consider it.
My lord, we have earlier also filed, my lord, in the same format, my lord.
When?
Earlier, my lord.
But this court has not accepted the same.
And the 7.
You comply with subsection 3.
100.
As prayed for by Mr. Uddin, learned counsel for the appellant. Recessal is the matter after 1 week so as to enable him to file amended cause title.
No.
Amended memo of appeal incorporating the substantial question of law in the memo of appeal.
22.
Okay.
Actually, please come to page 16. This is the downfield also. These are the substantial question of law also. Lordship is very correct. Just now, Lordship has said 3 we have to comply with now. So it is in the body of the EL also, which is my substantial question of law at page 16 also.
Yes.
Also, at this present stage, Lordship, I am in possession since the filing of the suit. There is no EL. Lordship can admit and the substitution of substantial question of law. Let them appear.
So you have
See, when Lordship can
suggested
see at
as many
page
as
5,
6.
Lordship.
Pardon?
Page 5, Lordship. That,
No, you have suggested as many as 6 substantial question of law.
yes.
Which according to you are most essential?
1, 2, 3, and 5.
1, 2, 3, and 5. Okay, what is page number 5?
Yes. That Lordship, I am in possession and ordered that. It is
It is the pleaded case of the plaintiff that the plaintiff number one has purchased the suit from C so and so so and so. Therefore, the suit line is self-equal property of plaintiff number one. Further, it is pleaded case of the plaintiff by way of settlement of the suit line, the settlement of plaintiff number one to arbitration of the plaintiff number two. Therefore, on the date of institution of the suit, plaintiff number two is the owner of the suit line. However, the player A, lordship, for that lordship can directly come to the plain. Lordship, I'll show
Page number?
page 31. Page 29 is the plain, lordship. And lordship, may please come to page 31st.
Yes.
This is in the cause title, a suit for declaration of the plaintiff's right, title and interest and confirmation of possession of the plaintiff and cancellation of sale deed in respect of the suit plan as given in the schedule A below. Now, lordship, may please come to para 2 at page 31. You see how the decree was passed, I do not know. After this pleading, lordship, it is something unbelievable, lordship. Paragraph 2, that the suit plan was originally belonged to so and so and so. While they were possessing the suit land, the plaintiff number one purchased the suit land from them, and accordingly, possession of the suit land was delivered to the plaintiff number one for more than 35 years ago. After the said purchase, the plaintiff number one name was duly mutated, and the plaintiff number one is became the recorded pattada of the suit land. Now, lordship, may please come to page 33. Page 33.
Yes.
Para 6. In the plain itself, there is a contradiction, lordship. How, lordship, this paragraph 6, page 33. That the plaintiff number one and the defendants are cousin to each other, and they have settled their landed properties among themselves. Accordingly, by the said settlement, the suit land settled by the plaintiff number one through arbitration with the plaintiff number two. But the plaintiff number two yet to mutate his name in the suit land, although he has possessed. Now there is a contradiction in the para 2. He said he is in possession plaintiff number one. Now said that the by an arbitration it was given to plaintiff number two. Then the prayer lordship can see. Page 35. It is all these are contradictory. Paragraph 6, paragraph 2. Evidence is something else. 35, lordship. A decree be passed in favor of the plaintiffs for declaration of right, title, interest and confirmation of plaintiff's possession over the suit land as described in the schedule. According to him, indeed, two is the imposition. He has already given up all these laws. So, lordship, page 71, lordship will get the contradiction. Page 71. What is given by the court in the order. Page 71, order A. The plaintiffs are entitled to a decree that the plaintiff number one, Devi Prasad Moore, has right, title and interest over the suit land. So, right, title and interest is in favor of the plaintiff number one. Now, B. The plaintiffs are entitled for a decree of confirmation of possession of plaintiff number two. Now, right, title, interest given to plaintiff number one. Confirmation of possession in favor of plaintiff number two. All these, my lord, this will not be done, lord. And the evidence, lord, I don't want to go. Evidence said that I am in possession all along, lord, my client. This is admitted into evidence, lord.
Court, Mr. S. Sharma, learned senior counsel, assisted by Mr. Learned counsel for the appellant. This second appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 10/6/2024 passed in title appeal number 1 of 2023 by the learned civil judge, senior division, Nagaon.
Page 16 is the substantial question. You can pick one copy of this. One, two, three, and 5.
Hmm.
I've given a copy, Lawsuit, but you can take that also separately. I have given.
All right. It is to be noted here. How much?
Excellent.
It is to be noted here that by the impugned judgment and decree dated so and so, the learned civil judge senior division, Nagaon, has dismissed the appeal and thereby affirmed the judgment and decree dated 23rd/11/2022 passed in title suit number 154 of 2007 by the learned Munsif number 1 Nagaon. Peruse the memo of appeal, the grounds mentioned therein, and also peruse the impugned judgment and decree dated so and so passed by the learned civil judge senior division Nagaon, and also the judgment and decree dated 23rd/11/2022 passed in title suit number 154 of 2007 by the learned Munsif number 1. The second appeal is admitted on the following substantial question of law. Whether the learned First Appellate Court committed perversity in not appreciating the pleaded facts and vital evidence on record that both the plaintiffs claim their exclusive independent ownership and possession over the suit land by way of purchase and settlement respectively, and in spite of mutually inconsistent pleadings in the plaint and evidence, the court declared title of the plaintiff number 1 and confirmed position of the plaintiff number 2 over the suit land. Number 2, whether the suit is maintainable under section 34 of the Specific Relief Act 1963 in as much as both the plaintiff themselves claiming exclusive right, title, and possession as to suit property by way of purchase and settlement respectively, and seeking relief to declare right, title, and interest and possession in favor of both the plaintiff. Number 3, whether the plaintiffs ought to have been non-suited for failure to prove their own title, adducing sufficient evidence to discharge the onus on it, and shifting the burden on the defendants in a suit for declaration of the title and possession of the plaintiffs. 5, whether 4, or whether impugned judgment and decree is hit by the provision of Order 41, Rule 31 of CPC in not framing issues relating to possession in spite of there being grounds in the memo of appeal. Let notice be issued to the respondents, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. Registrar shall call for the record from the learned. Also from the court of learned trial court. List the matter after 4 weeks. Till returnable that weeks.
Yes. I.
Number 23 matters for orders.
I stays there.
Yes.
Wait, my lord. I am for the respondent, my lord, but I have filed a missed case here, 2561, my lord, 24. For injunction, my lord. My lord, as a plaintiff, I have filed a title suit, my lord, before the Lord of Civil Judge,
We
Nagaon.
have filed our objections on 23rd. That objection is yet to come on the, in the record.
That's it.
Another date may be fixed so that the objection comes along with the main record.
My lord, in the meantime, construction is going on, my lord. Since August, my lord, I have filed this miss case on August 19, my lord.
Lordship, injunction petition order line, order 39, rule 1 and 2, in that injunct 2561, there is no schedule. On which schedule this going?
Schedule is in the
This honorable court will
judgment.
pass.
In the court below, my lord, civil judge as well as the appellate court decided in favor of me. Concurrent finding is
It
there.
is a case
Okay.
of specific performance.
And during the
of
pendency, my lord, they are
Mr.
raising
Mr.
construction.
Day,
My lord,
let the affidavit come.
Lordship.
may pray, my lord, may it tomorrow listed tomorrow as on the supplementary, my lord.
That's a hearing matter. We'll try tomorrow.
My lord.
As agreed by learned advocates of both sides, let's raise the matter tomorrow. In the meantime, the objection petition filed by Mr. Bhagwati, learned counsel for the you were for the appellant.
I'm for the appellant.
Appellant. Shall be placed on record.
Lordship.
Item 24.
Lordship, item 24, 25, 6 are similar matter. Here, Lordship, appellant had filed the RFA, Lordship. Then it come to the notice of the respondent. Earlier also, the respondent have filed a RFA against the same impugned order. So I took the objection that the second RFA is not maintainable. And the appellant itself, in his condemnation petition, your lordship will please to take up.
But the other side is absent today.
Now, he had taken return. Since many days, nobody is appearing on behalf of appellant. Thereafter, the honorable court issued the notice by the order dated, lordship, 18/6/24, were serving court notice to the appellant.
There's so क्या
Matter is pending since 2018, Lord.
So earlier, they were represented by learned
J.H.
counsel, Mr. Zayesh Soikia.
Yes, Lord.
But Zayesh Soikia withdrawn his ukalatnama.
Yes, Lord.
And thereafter, Registry has issued the notice
Yes.
on 17/9/2014. No, sorry, 18/6/2024.
Yes.
But till that, no counsel has been engaged by them.
Actually, the appellant, they are not having. any-
Interested.
And it is admitted such lordship, just your lordship will please to pay IN number 2445 filed by the appellant, where they have admitted that earlier they had filed the RFA, which was dismissed. Second time RFA can be filed again. See, saving from order.
Okay, let us fix a short date. If on that day nobody comes forward, then we will dismiss the
Short date.
short date. None appears for the appellant on call, applicant on call. How about Mr. S.P. Roy, learned counsel, appears for the respondents. Respondents.
Number one.
Respondent number 1.
Respondent number 2, Lord.
Respondent number 2. Office note dated 17/9/2024 indicates that notice was issued to the appellant number 1 to 7 by speed post on 18/6/2024, informing them about withdrawal of Ukalatnama by earlier engaged counsel, Mr. J. A. Soikia. But the appellants have not yet engaged any new counsel to represent their matter. List the matter on before vacation. This is the one party na 3rd of October.
Yes, all right.
3rd of October. Resisal also put up an up-to-date office note regarding service of notice dated 18/6/2024 upon the appellants.
Same order in 25.
Same order.
25? 26? Same order. 26 is same.
27.
27?
Yeah, please, Lordship.
Mm.
Lordship, this is a contempt petition for non-compliance of order dated 28/11/2018, passed by the rate petition number 59/2014 of 2014. Lordship, the matter is for non-inclusion of a name in the list of provincialization of service.
So, madam, have you filed a Ukala? Oh, no, sorry, there's a affidavit in opposition. Yeah.
Lordship, I'm for respondent number 5, your lordship. We have filed our Wakala number on 3/9, your lordship, 2024, your lordship. Lordship, I'll pray for some time to file our affidavit, your lordship. And lordship, the state has also filed a review petition, lordship, against the impugned order. It was filed on 10/9/2024, your lordship.
10/9.
Lordship, on 10/9/2024, your lordship.
You are for respondent number?
5, your lordship, Narayanpur.
So here only 4 respondents are. Yeah.
Lordship, later on, I think we were included, your lordship. Narayanpur was included. Your
But whether this cost title was amended cost title was filed. Correct. 4.
Lordship, we have filed amended cost title.
When? Who is that? It was filed.
Lordship, on 2023, Lordship.
2023. Madam, you please check the record. Whether you have filed amended cost title or not. We'll take it up after some time.
Item 28.
Bangalore.
Construction size, sir.
Pardon?
My lord, matter of 2021, my lord.
Hmm.
Affidavit has yet been filed. We have challenged an order, is at page 35. My lord, my gap period had been regularized, stating that only the pensionary benefits shall be, my lord, given to me, but not other financial benefits.
Hmm.
But for that gap period, my lord, I am also entitled for my salary also, my lord. But they are not providing me, my lord. What is the reason, my lord, that has also not been
No,
disclosed?
no, whether it is provided in the order.
My lord. Yes, my lord, kindly turn to page 35, my lord.
Lordship, here I have received the instruction, your lordship.
Hmm.
It has not been done in disbursed due to non-availability of retention, your lordship.
That can be, they can my lord, regularize if retention is required, my lord. They can do it, my lord.
So this is the only reason, your lordship.
Retention?
Of that particular
The
post. my lord.
particular post, your lordship, which the petitioner is holding, your lordship.
You have filed your affidavit?
Yes, your lordship, I can.
When?
Within 2 weeks, your lordship.
Acha, you have not yet filed.
Oh,
No,
your lordship. We have received the instructions, your lordship.
Within 2 days.
Yes.
Let them file.
my lord. Report.
Heard Mr. A.R. Bhuya, learned counsel for the petitioner, and Ms. Teran P, learned counsel for the standing counsel for the respondent number.
Respondent number 1, 2, your lordship. All the respondents.
Refer to standing counsel for the respondents. Ms. Teran P submits that she has received written instruction and she will be filing her affidavit in opposition within 2 days from today.
Lordship, 2 days will not be possible, your lordship, because we have to send back again for reading, your
This is
lordship.
2021 matter. Okay, on recess the matter on 1st of October.
My lord.
29.
Oblige.
I have challenged the appointment, the promotion of my lord, respondent number 5, Bobita Inki, my lord, who is 12 years junior to me, to the post of headmaster, my lord. Your lordship may come to and see the imprint order, my lord. Your lordship may take the writ petition, my lord.
Hmm.
Imprint order is at page, my lord, 32, my lord. Lordship may take it, my lord.
Hmm.
Page 32, my lord. May I read, my lord?
Yes.
In pursuance of KAC letter number so-and-so dated 27th March 2022, issued by the Deputy Secretary, Department of Personnel, Karbi Anglong so-and-so, Difu, and in the public interest service, Mrs. Bobita Inti, Atharpi, MA History B.Ed, Assistant Teacher Graduate of Longleat High School, is hereby promoted to the next higher rank of full-fledged headmaster with transfer to act as a headmaster of Kirdip High School in the scale of pay so-and-so with grade pay so-and-so plus other allowances as admissible under the rules with effect from the date of joining as Vice Durgeshwar Saikya Headmaster of Kirdip High School transferred to Longleat High School. Now, my lord, she has been brought to the Kirdip High School from Longleat High School and promoted as a post of headmaster, my lord. Completely divorce the rules, my lord. If your lordship see the rules, my lord, and she is 12 years junior to me, my lord. The rules, my lord, at para 10 of the, I have, the page 10, I have incorporated the rules, my lord. Lordship, may see, my lord. 14, para page 10, my lord.
Yes.
The recruitment of the post of headmaster, superintendent, and procedure thereof. The post of headmaster of a high school and superintendent of a high madrasa shall be filled up by promotion from the candidates among the graduate teachers as per district-wise seniority. So there has to be district-wise seniority list, my lord. On the recommendation of the district selection committee constituted under the rule 16.2. the selection of headmaster and superintendent shall be based upon seniority. First is seniority, my lord, and satisfactory annual confidential report for the last 3 consecutive years, so and so. Provided that the seniority of the graduate teacher shall be determined from the date of receiving graduate scale, so and so. Now eligibility is there, my lord, and
So now you tell me when you have received the graduate scale.
I have received graduate scale for pay, my lord, from 1/1/13, my lord. So
1/13.
1/1/13. So
And the other person?
other person, my lord, graduate pay scale 2nd November 2004, my lord. He's from a different school, my lord. So it cannot be, my lord. The normal process is that if he is in different school, he cannot be brought into my school, my lord. So here he was teaching in the Longdit High School. So he had been brought, she has been brought to Kirdeep High School and got the promotion to the post of headmaster, my lord. The lordship may see that promotion order. They filed their affidavit, my lord. Affidavit.
Where is the transfer order of the respondent?
Promotion order. This promotion cum transfer order, my lord.
Yes.
That is page 32, my lord. That is in order. Now, how she is promoted, my lord, they have annexed the copy of that. I'll to place first, my lord, page 44 in the affidavit in opposition, my lord. Page 44, my lord. Here, there is the communication, my lord, from the Additional Secretary Education Department to the Director of Secondary Education. That is 23rd November, February 2022. Page 45. Now, this is regarding promotion to the post of headmaster of provincialized high school. With reference to the subject cited above, I am directed to inform you that in respect of schools provincialized in the year 2013, graduate teachers of these schools have not completed 10 years of, like my school, my lord, the Kirdeep High School, 10 years of service on which they, which is mandatory for promotion to the post of headmaster as the Rule 14(2)(b) of Assam Secondary Education Provincialized Schools Service Rules 2018, and minimum of these schools provincialized in the year 2013 shall be completing 10 years minimum service on 1/1/2022, and therefore the school provincialized in the year 2000 should be kept out of the purview of promotion of the regular headmaster, which is under process till 31st/12/2002 and until further order. So the protection was given to that school, my lord, that because 2013 the school was provincialized, and therefore, my lord, that they should be kept out of the purview of that regular selection, my lord. But here is the person, my lord, who is 12 years junior to me in a different school, been brought in my school and got promoted to the post of headmaster, my lord. Now, lordship, see second, my lord, lordship may see the recommendation, my lord, page 46. Same affidavit, my lord. How the departmental promotion committee has been constituted. Totally illegal, my lord, not as per rules. May I read, my lord? Page 46, my lord. Minutes of departmental promotion committee meeting held on 24/3/2022 at 12 noon in the office chamber of Secretary Education, so and so. Now, this constitution, my lord, the committee, my lord, this is not as per rules, my lord, because rule says something different, my lord. This has not been constituted as per the rules, my lord. Now, then also, my lord, lordship may read this recommendation, my lord. The meeting of the departmental promotion committee. Now, there has to be selection of headmaster, my lord, but there is now, here is the department committee for promotion, my lord. Was presided over by Secretary Education, Karbi Anglong so and so, and chairperson of the departmental promotion committee. The chairperson welcomed the members present in the meeting, the Departmental Promotion Committee discussed the proposal of the inspector of school. There is no question of any proposal, my lord. They have to make district-wise seniority list, my lord. So there is no, that inspector of school will put a proposal, my lord. There is nothing like that, my lord. Proposal of Inspector of Schools, Karbi Anglong District Circle, Difu, on the matter of promotion with transfer from the present post of assistant teacher graduate of Longleat High School to the next higher rank of headmaster are to be transferred to Kirdip High School in the same capacity. On the placement of the proposal of the committee verified all the documents. On the verification, the committee found that Srimati Babita Inti Karbi Katharpi was appointed as assistant teacher graduate, white order number E, so and so 1/11/2004. She joined in the Longleat High School on 2/11/2004. She has qualification of MA BL. She is senior most graduate teacher of Longleat High School. She may be a senior most teacher in the Longleat. That is a different school, my lord. As per graduation list of Longleat High School, and has completed 17 years, 4 months and 20 days continuous service as on 21st/3/2022. She has the requisite qualification and is eligible for promotion to the post of headmaster of the high school. Nothing adverse report was recorded in the annual confidential report for 3 consecutive years. As such, the committee, after a threadbare discussion, decided for recommendation of promotion to the next higher rank of headmaster in respect of Srimati Babita Inti. The committee directed to consider the department took necessary accordingly. Now, next, my lord, page 47 we seen, my lord. On the basis of
Mr. Roy, you tell me who maintained the gradation list?
this is a district wise, my lord.
District wise.
I'll show the rules, my lord.
They belongs to same district,
Same district, but the school is different, my lord.
maybe. But if the,
Yes, that may be, my lord. But lordship, if your lordship see the rule 14(2)(b), my lord. In fact, they have also shown their own, my lord, recruitment rule. Page 40 may be seen, my lord, paragraph 9.
page
40. Then, like 14 is the education rules, my lord, but they have their own, their notification, they frame the rule. Clause 11, recruitment to the post of headmaster. Number 11.1, the post of headmaster of a high school shall be filled up by promotion from the candidates among the graduate teachers as per district-wise seniority list on recommendation of the district promotion committee constituted by the authority. Now they have to first form a district-wise seniority list, my lord. There is no district-wise seniority list as per the recommendation which I have read it, page, my lord. They have not formed a district-wise seniority list, page 46, my lord, the recommendation which they have given. Now next, my lord. The minimum qualification for appointment to the post of headmaster of
no, if they have their own rule,
yes,
then
This
how
change.
this rule 14 will help you?
no, rule 14 or is same, my lord. They have copied the rule 14. Here it is rule 11, my lord. Now next, my lord. The minimum qualification for appointment to the post of headmaster of a high school shall be as per norms laid down by the government Assam. Now 11.3. The selection of headmaster shall be on seniority and satisfactory annual confidential report for the last 3 consecutive years. The seniority of the graduate teacher shall be determined from the date of receiving graduate scale of pay. So also, no, I'm not in that. Now 11.4, my lordship, the district promotion committee constituted by the authority of KAC shall hold interview. There is no interview in that recommendation, my lord. Neither a seniority list is there, neither an interview held. Hold an interview, verify the records pertaining to seniority of eligible teachers for such promotion and evaluate the merits of the eligible candidates for promotion and prepare a select list equal to the number of vacancies. There is no vacancy has been assessed by the committee matter. Simply somebody is picked up from the another school and been promoted in the different school, my lord. So there is no select list. There is no district seniority is prepared. No interview was held. Then next, my lord, the approval of the select list by the authority KC, the appointment shall be made as per preference and merit in the list. The validity of the list shall be beyond 1 year. So this is now clause 14 may be seen next page, my lord, page 42. District level promotion committee shall be consist of the following members. First three are there, my lord. And there is no one educationist nominated by secretary is not there, my lord. One principal retired higher secondary school, this is not there, my lord. Lordship may see the list, my lord, page 46. What is the formation of committee, my lord, there? There is no, the 2% is not there, my lord. So this committee also not formed properly, my lord. They have done it hastily, my lord. She has been promoted on the proposal of inspector of schools, but there cannot be any proposal from the inspector of schools, my lord. There has to be first district was seniority list, then they have to call for interview. Now, when the matter had come up on 22/12/2003, there is an order of justice, Honorable Justice UK my lord, Lordship peruse, my lord, order dated 22/12/2023, my lord. In the file, my lord, Lordship will get it. 22/12/2003.
22/12.
12/2023, my lord. Last 2.5 years, my lord, I am fighting for this, my lord, case. Now, Jogeshwar, my lord, who has been transferred, but he is not challenged, my lord. But that does not actually Jogeshwar, Jogeshwar Saikia, my lord. He is not challenged that he is transferred to the other school, my lord. Now, my lordship may see this order, my lord. On the next day, Mr. R. Rongham, learned standing counsel for the KSC, shall place on record a copy of letter dated 27/3/22, along with the record of selection. The record of selection, my lord. A person to which private respondent number 5, namely Babita Inti Katharpi, came to the promoted by order dated 28/3/22 to the post of headmaster at Kidlip High School. It is the submission of Mr. J. Rao Leonard, senior counsel for the petitioner, that Mr. Jogeshwar Saikia, who was headmaster of Kidlip High School and transferred to Longleat High School in terms of order dated 28/3/22, is stated to be retiring on attaining age of superannuation on 31/12/2023. The said post be not filled up on regular basis till the next day. However, in the event of necessity is felt, the respondent authorities may allow an eligible incumbent Longleat High School to hold the charge of post of headmaster of the said school. But this has been done because, my lord, from Longleat High School, she is been transferred to Kidlip High School, my lord. That's why this post was kept vacant, my lord, because when I shown that Jogeshwar Das, who was transferred to Longleat High School from Kidlip, my school, my lord, he retired, my lord, and they want to fill up that post. So this post is not filled up because of that, my lord, because she has been transferred to my school, my lord. So she has to come back to her school, my lord. That's why this post was kept vacant, my lord. Now, my lord, in fact, last occasion, my lord, I filed an additional letter with my lord, which may be seen, my lord. Page, my lord, it's page 50, my lord, I have stated, lordship may see, page 51, my lord.
Yes.
Yes, that there is an order, my lord, which is annexed in the gradation that they have been regarding document verification of teachers. There is a gradation list, my lord. Dated 6/7/2024. In this, with reference to the subject cited, lordship got it. With reference to the subject cited above, I have the honor to enclose herewith the list of graduate teachers of your respective education institution for verification of documents for preparation of district-wise seniority relation list of graduate teacher under Karbi Angla for favor of information necessities. Now, they have followed the procedure, my lord. They have prepared the district-wise seniority list, my lord. Now, here is that, my lordship may see the next page, my lord. Serial number 12 may be seen, my lord. Kidlip High School, my lord. One Anamika Bora, madam. She is not the senior most teacher. I am the senior most teacher as per gradation list which I have announced along with my petition, my lord. Lordship may see the page 31, my lord, of the writ petition.
Page
31 of the writ petition, my lord.
Yes.
Graduate cadre, my lord. Serial number 5 is Rekhamani Bora, then Anamika Bora. Now she has been called by the district for senior list. Her name appears, my lord. I'm not there, my lord. Neither I know about. So when I came to know, I filed this additional affidavit just few days back, my lord. So this is what going on in the school, my lord.
Now, what is your prayer in this petition?
My prayer is that to set aside the appointment or promotion of the private respondent number 5, my lord, and
Who is for the private respondent number 5?
First, we look into the whether notice has been served on the respondent number 5 and 6, my lord.
so that
The
is served, my
orders,
lord.
it is listed for orders, my lord, whether if it is not, Lordship may accept it, the notice has been served, duly appeared. I think Lordship may office note is there regarding the service of notice to the respondent number 5 and 6.
It is served.
And today it is listed for orders, my lord. If your Lordship wants to disposal, final disposal, Lordship may fix it for final disposal on any other day. For
Without
final
hearing the
disposal.
other side, can we hear the matter?
No, final disposal, Lordship, it cannot be, my lord, it
My
may not be, my lord,
government
for
has to
final
defend its
disposal.
action, my lord.
Pardon?
We'll defend it, my
Government
lord.
has to defend its action, my
We'll
lord.
defend it, my
And
lord.
private respondent, I've been told that the notice has been served, my lord. 6, 7, service. Lordship may peruse the office note, my lord. My learned friend wants to take time, well, my lord. Well, on first, let it be on first, my lord. But I'm 2.5 years, I filed this petition, my lord. And a person who is 12 years junior to me has been promoted in my school and brought in, my lord. And they have protected me, my lord, as per the affidavit of the government, like my learned friend, it has been there, my lord, that note. That is page 44, my lord. Because there is always an animosity, my lord, when somebody is brought from a different school, my lord. Where there is nothing on the basis of a proposal of the inspector of school, he has been promoted, my lord. That there is no question of proposing somebody's name for the post. There has to be district for seniority list. That has to be considered. Then there will be interview. That's why, my lord, the learned judge on earlier occasion, my lord, has called for the selection of.
So there is one order of the Law Jemma Court where it is stated that service is completed in respect of respondent number 5 and 6.
Yes, that is completed, my lord. So if she doesn't want to appear and to contest it, then I can help it, my lord.
But since the matter is listed today in orders column, let us fix a short date.
Let it be first, my lord, on, it can be decided, my lord, first.
Which one?
This matter, my lord, on 1st of October, my lord.
1st of October.
October.
Yes, other side is ready.
For final disposal. For final disposal.
Okay. Heard Mr. Zairoy, learned senior counsel assisted by Mr. Hazarika, learned counsel for the petitioner, and Mr. Jay Sutia, learned counsel for
Standing counsel for KAC.
standing counsel for KSC, and Madam. Respondent number 1. Respondent number 1. It is submitted at the bar that the service in respect of respondent number 5 and 6 completed, and as such, the matter may be listed for admission hearing. Accordingly, it is provided that recessal list the matter on 1st of October, and on that day, an endeavor will be made to dispose of this petition.
I mean 27. Interim order to continue, my lord. It is an order.
Interim order passed earlier shall continue till then.
Minute petition, external fiber can level consider appearance.
So, madam, some defects are there. You have to file the amended cost title.
Lordship may allow to file a fresh amended cost title, Lordship.
Your good name, please?
Armidi.
R. Medhe.
Yes, Lordship.
Heard Miss R. Medhe, learned counsel for the petitioner, and Madam
D. Musahari.
D. Musahari, learned
Respondent
counsel for the respondent number 5.
5.
Respondent number 5. None appears for the rest of the respondents. The learned counsel for the petitioner submits that she may be granted some time to file amended cause title of this petition. Where is accordingly allowed, races alleged the matter after vacation or before vacation?
Lordship,
After vacation?
yes, Lordship, after
Okay.
vacation.
Okay.
Obliged.
Item 30. Please, your lordship. Lordship, in this case, LCR to be called for lordship. Just come for order, lordship.
Is it necessary to call for the LCR? This is CRP only.
Lordship. There is an interim order of party.
What is the matter?
Lordship, we have filed a petition for amendment of plain lordship, which was subsequently dismissed lordship.
Hmm.
Challenging that order, we have filed this CRP.
So why record is necessary?
Last occasion, record was not filed. Lordship. So it may be come for admission, lordship. Date has come for order.
Okay, I heard Mr. Bardolo, learned counsel for the petitioner and madam.
J. Singh,
Jai
appearing on
Singh,
behalf of GJ Saikya.
appearing on behalf of
GJ Saikya.
G.J. Soikya, learned counsel for the respondent. It is submitted at the bar that the service completed and matter is ready for admission hearing. Accordingly, it is provided that recessal is the matter when
After vacation, lordship.
After
First week of
vacation.
November.
first week of November.
Lordship, interim order
Interim order pass service shall continue.
until further order. Lordship.
Okay.
31. Oblige, your lordship. Very pleased, your lordship.
Hmm.
Letter relating to my according approval to the newly constituted school managing committee.
Hmm.
The law is that, my lord, when the school managing committee constituted, my lord, the respondent number 3, respondent number 4 is duty bound to accord approval to the newly constituted school managing committee within 1 month from the date of receiving intimation.
Hmm.
Here the school managing committee was constituted on 5/10/2023.
Hmm. Hmm.
Then, while for the post of president, election was held on 17/10/2023. But on that election, the petitioner won by margin of 5 votes, defeating his rival. Accordingly, the school managing committee was constituted.
Hmm.
Regarding constitution of the school managing committee, the respondent number 5 intimated the respondent number 4 to accord approval
Hmm.
on 31/10/2023.
Hmm.
But even after lapse of almost 1 year, no approval is granted. Well, according to my rule 13(3), Roman 5 and Roman 6,
Hmm.
respondent number 5, respondent number 4 is duty bound to accord approval within 1 month from the date of receiving information regarding constitution of the school managing committee. There's the inquiry report is also there, my lord, here. The election was conducted in free and fair manner under the supervision of the observer, my lord. And also, my lord, proceeding of the meeting also filed page 21, instruction on page 21.
Hmm.
The proceeding of the meeting, that order next meeting, my lord, general meeting was held.
Yes, Mr. Talukdar, have you filed your affidavit?
No, my lord, the instruction is awaited, my lord, and the approval approved by the deputy commissioner, my lord.
Hmm.
No, no, district limited resources.
That's number 3.
Question number 4.
So lordship may taken up immediately after vacation. In the meantime, you will take the instruction, my lord. And if necessary, then I will file the affidavit after receipt the instruction, my lord.
Settle, my lord. That, my lord, rule 13(3), Roman 5 and Roman 6
Hmm.
of Assam Right to Child to Free and Compulsory Education Rules 2011.
Hmm.
You also find it in education manual, my lord.
And my lord, respondent number 6, my lord, service may be not
The
completed.
headmaster of the school, my lord, as per the office note dated 11/6/2024, my lord, service is completed, my lord. And so far as the respondent of 6 is concerned, he is a member secretary. So he also submitted a
So
report.
you were referring to which rule
13(3), Roman 5,
of Assam?
Assam
Like to,
My lord, some right to child to free and compulsory education rules 2011.
Rule,
Rule 13, 3, Roman 5 and 6.
approve it, ma'am. This was a, like, it's on this for approval. Otherwise, Lordship may dispose of the matter. His only prayer is to approve
Only
the
approval.
Yes.
approval. So Lordship may direct the
That's one of
correspondent for to approve the commitment. Lordship may dispose of the matter.
so you are referring to rule 5,
Rule 5 and 6, man.
5 and 6. Where it is provided that one week within,
1 month.
One
from the date
month.
of receiving intimation.
where it is provided?
Sorry, my lord, sir, book is concerned.
Acha, you have no book.
My lord,
Education manual. আগৰ কোনো নাই। Like, RTA.
Here it is mentioned rule 5 within 3 days from the date of receipt of the resolution.
Yes, resolution adopted on, my lord, 10/7/5/10/2000. Did you also find page 21?
Resolution was adopted on
Page 21, my lord. On 5/10/2023 and 17/10/2023
5/10.
and 17/10. It was finally constituted on 17 because on 5/10, 12 members were constituted. So
No,
far as
5/10 of which year?
of 2023.
And in fact, finally constituted on
On
17/10.
17/10, because there has been no consensus in the election of the president. So the minor general meeting decided on 5/10/2007 to hold an election by way of casting vote for election of the president. So on 77, election was held and the present petitioner was elected as the president. And finally on 17/10.
So on 17/10, resolution was adopted.
Adopted, man.
And it was communicated to
On
the
thir-
district elementary education
On
officer,
31/10.
31/10.
There you also find page 35.
Page number,
Page 35. Respond number 5, communicator sent to
page
respondent.
35.
35, man.
Yes.
Then you'll also find some inquiry report that regarding holding free and fair election, page 36. And the report of the member secretary, my lord, headmaster of the school, respond number 6, he's also given a report. The election was held in accordance with them. That you'll also find at page 50. Page 38. And the 3 observed were present while holding the election, my lord. Their report is also there, my lord, that I have enclosed, my lord. Page 38.
38 is the report.
No, 38 is the, my lord, is headmaster, yes, 38, yes, headmaster. You also find page 40 onwards.
So as per this rule, 3 Roman 6. Uh, 13/3 Roman 6. Within 1 month, the district elementary education officer has to approve the
Yes, ma'am.
proposal.
Proposal. 41 from the date of receiving intimation. Intimation is given 31/10/2023.
And when he received the resolution? Same day?
Same day, my lord. Same day. Same day, then he ordered for inquiry. Whether the election was in free and fair manner, my lord.
Hmm.
Then the block development officer conducted an inquiry. Then you also file inquiry for page.
Okay, then we'll dispose of the petition. Any other rule you are referring to? Apart from this 5 and 6? Roman 5 and Roman 6?
My only concern is approval. Granting approval to rescue management committee, nothing else, my lord. Because presently the old managing committee, whose term is expired after 1 year there, he is my running.
Expired when it was expired?
Expired, my lord, in the, my lord, September 2023. In the month of September 2023.
কালি ফোন কৰিছিলো।
Oh, we forgot to call. It's very important. The 36 will also find the inquiry conducted by the blockage order elevated officer. Page 36.
Okay. The petition disposal.
Only that if not approved till date.
Not yet, yes, not yet approved, my lord. Not yet
Because
approved.
recent instruction, I don't have my lord.
No,
Whether
sir.
it is approved or not.
Yes,
If not approved, then also may directed to approve.
yesterday I received information, not yet approved, because the earlier managing committee, whose term expired in the month of September 2023, is still continuing.
Plus,
Well, the school name is, my lord, Sunai Bibi Balika LP School.
It is mentioned in
Yes,
the
yes,
petition.
mentioned.
Oh.
All right.
32. May page alone. Lordship, this I saw condemnation of delay only 9 days, Lordship.
What is the ground?
Lordship, ground I have stated from paragraph number 3, Lordship.
No, you tell me what is the ground.
Lordship, the tribunal has passed the judgment on 23/4/2024, and the dealing advocate appeared before the tribunal, Lordship, applied for certified copy on 2/5/2024, Lordship, and same was received on the same day, Lordship. Thereafter, engaged advocate handed over the certified copy of the judgment along with the record, Lordship, to the regional officer at Guwahati on 26/5/2024, Lordship. So thereafter, Lordship,
Let notice go at this instance.
Lordship,
Art Mr.
Harsha Malad.
Learned counsel for the applicant. The Oriental Insurance Company Limited. Application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 9 days in file preferring appeal against the judgment and award dated 23rd/4/2024 passed by the learned member MSCT Kamrup M and Guwahati in MSC case number 650 of 2020. Where is the petition and the documents placed on record? Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks. 9.